The Honorable Chief Justice and Justices of the Supreme Court of Pennsylvania. Oyez, oyez, oyez. All manner of persons who stand bound by recognizance of who otherwise have business before this court and now appear in the shall be heard. God save the Commonwealth and this honorable court. Please be seated.
Good morning, everyone. Good morning. Welcome to the first day of our fall oral argument session here in our state capitol in Harrisburg. As you may know, because I say it all the time, our Supreme Court is the oldest court in North America, and it dates back to the Pennsylvania Judiciary Act of 1722 when it was formally established. However, it actually has its roots in William Penn's Provincial Court of 1684. When this Capitol building was dedicated in 1906, President Roosevelt attended the dedication and declared this to be the handsomest state capitol he'd ever seen. The architect of the building envisioned this to be a palace of art, and in no chamber was his vision as well embodied as in this courtroom. On May 23, 1927, the Supreme Court of Pennsylvania convened at 3:30 in the afternoon to unveil the majestic violet Oakley murals that you see all around you in the courtroom. Ms. Oakley was selected by the Capitol architect, Alfred Houston, in the hopes that providing such an opportunity might inspire other women to pursue art. At the time, such a commission was a radical concept. She was the first female artist to receive a large public commission. Ms. Oakley proved to be up to the task. Already a well-regarded artist from Philadelphia, Oakley's work in this building made her world-renowned. Oakley's vision for this room was to write a book on the evolution of law, and the murals in this room may remind you of the pages in a medieval or Renaissance manuscript. Senator George Wharton Pepper remarked that Oakley's murals would remind the justices of their solemn duty and the advocates to restrain their passions and compel candor, and that these paintings would serve as a silent but convincing witness to those things without which we build in vain. Before we hear the first case, I would like to remind counsel of a few things. Appellant's counsel, please approach the podium when your case is called. I will then give a short summary of the case. You may then begin by stating your name and the party you represent and introducing your co-counsel to the court. As you probably know, the justices are familiar with your case, so I ask that you avoid any unnecessary recitation of facts or procedural history and instead focus on the main issues on which we granted review. Counsel is welcome to rely on their briefs for particular issues. In cases where there are multiple parties represented by separate counsel, you should avoid repeating the same arguments as prior counsel. Please try not to interrupt the justices when they are asking you a question. A justice's question is not meant to trip you up. Rather, it indicates there are particular issues we would like to explore further. I remind you also that we do not permit rebuttal. While there's no set time limit for argument, I will advise counsel when the court is satisfied that all of the questions have been answered, and at that time, I will ask that you conclude your argument. Mr. Minner, would you please call the first case?
Larry Krasner versus Senator Pro Tem Kim Ward et al., representing Mr. Krasner, Mr. John Summers, representing Senator Costa, Mr. Corey Woods, representing President Pro Tem Kim Ward, Mr. Matt Haverstick, representing Representative Bonner et al., Mr. Robert Gracie.
Thank you. Good morning. This matter comes to us on direct appeal from the Commonwealth Court and concerns the General Assembly's exercise of its impeachment powers under the Pennsylvania Constitution. In 2022, on the last day of the 206th session of the General Assembly, the Pennsylvania House of Representatives passed articles impeaching the District Attorney of Philadelphia, Larry Krasner. Also on that day, the General Assembly appointed impeachment managers and transmitted the articles of impeachment to the Pennsylvania Senate for trial. The district attorney filed a petition for review in the Commonwealth Court challenging his impeachment, asserting that the impeachment proceedings violated various provisions of the Pennsylvania Constitution. President Pro Tem Kim Ward and the House impeachment managers filed a response to that petition. Senator Jay Costa, the minority leader of the Senate, was granted intervener status. As threshold matters, the Commonwealth Court held that the district attorney's challenges were both justiciable and ripe for review. On the merits of the controversy, although the court ruled against the district attorney on 2 of his challenges, it ruled in his favor on the remainder, determining that the impeachment proceedings contravened certain provisions of Article 6 of our Constitution. The district attorney and the President Pro Tem and the House impeachment managers have each appealed aspects of the Commonwealth Court's order, challenging both the threshold and constitutional rulings below, and we consolidated those appeals. The district attorney has been designated the appellant before us for purposes of argument. Welcome.
Good morning, and may it please the court. My name is John Summers. I represent Larry Krasner. With me is my co-counsel, Matt Hammermesh, and Andrew Erdlin. Senator Jay Costa is also an appellant, and he will address one of the issues that I will raise, the sine die issue, from an institutionalist and from an historical perspective. Good morning. The central concern in these appeals is whether the statewide General Assembly may impeach and convict a local prosecutor for his lawful, that is, not improper or corrupt, exercise of his discretionary duties. Since the founding of this Commonwealth, either in 1681 or when this Commonwealth joined the Union in 1789, our research reveals that there has been no impeachment effort like this one. There has never been an impeachment effort where there has been an effort to impeach someone who didn't engage in a corrupt or improper action. Yes, Justice Mundy, any misbehavior in office, and I will address that in detail ahead, refers to, under this court's precedent in the adjacent removal context, where misbehavior in office is recognized. It's the common law crime of misbehavior in office. It's the failure to have exercised a statutory duty, positive duty, or it's an officer's exercise of a discretionary duty with a corrupt or improper motive.
Counsel, I don't want to hijack your plan here. I have some reluctance to even delve into the question of whether, at least at this stage, whether what the House has charged the district attorney with, the substance of whether those substance rises to the level of a convictable offense from a judicial restraint perspective. Can you concede, or do you concede, that it's possible you could raise these very arguments with the Senate, and the Senate would vote to not convict based on the fact that the charges from the House do not rise to the level of offenses that warrant removal from office, and therefore we wouldn't have to decide this case at all?
The Senate, no doubt, could, and it should, if given the opportunity, not convict Larry Krasner because he didn't do anything impeachable. However, there are a variety of grounds that have been raised by the respondents for why this court should defer and not rule on this issue. one of the issues that has been raised is, well, it's a political question, and the court should not get involved in this dispute because it's a political question. Well, the problem with that argument is multiple. One, the Article 6, Section 6 language, misbehavior in office, is the same as the removal provision, misbehavior in office in Section 7, and the court has many, many times ruled on that, not concluded that an interpretation.
I'm going to go back to my question. You seem to concede, then, that the Senate could give you the relief that you're asking for here if we allow the Article 6 process to proceed, because the judiciary is not mentioned in Article 6. If we allow the Article 6 process to proceed, all these arguments that you're raising on whether these warrant removal or further action by the Senate are matters that the Senate could at least address in the first instance, and maybe we have to get involved later, but maybe we don't have to get involved at all.
The problem with that position, Your Honor, is that it doesn't reflect the standing and the ripeness doctrine of this court. That is, the question is, has Larry Krasner already been aggrieved? And the answer is absolutely. He's been impeached. That's a stain.
Well, well,
It's
it's not as much of a stain as a conviction would be, and he can be vindicated in the Senate.
It would take a 2/3 vote as compared to a majority vote.
Right.
But he's the chief legal officer.
2/3 of the Senate would require a bipartisan act.
He's the chief legal officer of the city of Philadelphia. He's got hundreds and hundreds of employees. The fact of an impeachment is seriously aggrieved him.
I understand.
That's harm. But Your Honor,
Counsel, just for a second, this argument that you're making would apply to every impeachment. That if the impeached officer is aggrieved by the impeachment in and of itself and has valid arguments to challenge it, they could run to court, to Commonwealth Court, and basically get a motion to dismiss in a court when really the Constitution says you go to the Senate.
the Constitution in no way prohibits this court from doing its job, which is interpreting the terms of the Constitution. This situation is like the following. If there is a civil complaint filed, the question is, does it state a claim under the law that it's purporting to do? We allow judicial intervention to stop the proceedings at that moment if, in fact, there's a failure to state a claim. That's precisely what we're doing here. You don't have to, as a...
It's not a civil action. This is in your scenario, your hypothetical, the action was brought in the courts, and the motion was made to the court to stop the action. This action was brought in the General Assembly, a co-equal branch of government, and you went to the courts. You jumped out of that forum into the courts and are asking the courts to stop another co-equal branch of government from moving forward with the Article 6 process. That's different than a motion to dismiss in the court where the action is actually filed.
Justice Brobson, there's a fundamental right that Larry Krasner has when he's being accused of something by a non-judicial body that has made allegations that don't come anywhere near stating a basis for impeachment, don't come anywhere near stating a basis for misbehavior in office, and challenging it. Because if he doesn't challenge it then, it's going to be too late. The time to challenge it is just like the time to challenge the sufficiency of a civil complaint or the sufficiency of an indictment. It's at the time of the indictment or the time the complaint's filed. And that's what he did. And if he and courts all the time don't say to the civil plaintiff, well, you know, you may be found not liable, so we actually don't have to go later challenge what a subsequent jury verdict does. That stands regular rule of law legal process on its head. And it's particularly important in a moment like this, where we have such an extraordinary and unprecedented effort to impeach someone. Now, I had intended to structure the argument to first address the misbehavior in office issues. That is, that the articles of impeachment don't allege an impeachable offense, and to take up the justiciability arguments. The fact is, Justices, they don't allege that Larry Krasner exercised his prosecutorial discretion in some corrupt or improper way, and I will address that in detail during the course of my argument. It's also the case, as our briefs extensively argue, as do the respondents, and I think the one thing we can agree on in this is that your honors have very extensive briefing. And the two other issues, namely whether the articles of impeachment have now died as of November 30 with the end of the General Assembly, and then also the issue that Larry Krasner is a locally elected official, and therefore the statewide General Assembly shouldn't be having the power to impeach him. And I'll address each of those things in detail. And before I do, I just want to highlight the importance because of this matter. These appeals, on the one hand, are about the General Assembly's impeachment and therefore really effectively effort to nullify the city of Philadelphia's voters' choice for who they want as the DA. Larry Krasner was elected in 2021. He was reelected in 2021. At that time, all of his policies were well known. He had run on those 4 years earlier. He had begun to implement them. And in the primary, he got 2 of 3 votes cast. And in the General Assembly, he got 72% of the vote, a 42% margin.
Could you, and I hate to throw you off track, but I guess I wonder why you wouldn't start with the issue that would bring a conclusion to this matter in its entirety, and that is whether or not the adjournment effectively ended the impeachment process. I mean, and do you agree? I mean, if we agree with you on that point, that's the end of the discussion.
Yes, I completely agree with you that would end the discussion. I started with misbehavior in office, Your Honor, and planned to do that because that's the issue that we won on in the Commonwealth Court below. Each of the 3 issues independently, that is, if we won any one of the 3 issues, we would be in a position to have the impeachment process stopped. Would Your Honor prefer me to start with the sine die issue?
Yes, I would. I mean, if that doesn't throw you off, I mean, it to me sort of sets the stage for the consideration of the other issues.
Of course, Justice Donoghue. This issue that the articles of impeachment are dead is actually really simple. It's got a fancy name, sine die, that people dispute actually how you pronounce it. But you know, what it really is that the Constitution provides that the body, the General Assembly, lasts for 2 years. And it's got to finish its business in 2 years. There's no carryover business. That's what Article 2 says. And here, the articles of impeachment, Justice Donoghue, as you noted, were passed in mid-November, before the stroke of midnight on November 30.
Should it concern us, Mr. Summers, that, or is it a relevant consideration as we interpret the Constitution with respect to this point, that an officer subject to impeachment could effectively run the clock out, given the speed with which a 2-year term expires? Is it in fact likely that any officer would be able to run the clock out, thereby effectively nullifying the impeachment provision.
Justice Wecht, in fact, the case we have here is one where that actually proves the opposite. That is, we have a situation where the Select Committee and the House acted on the heels of the end of the General Assembly, and perhaps coincidentally, it was after an election in which the House flipped parties. And so if someone's playing a game with the timing, it's actually doing it at a time at the end of an election and freezing in place where an impeachment that it otherwise couldn't. Look, if the rules of the road were clear that impeachment is no different, and I would respectfully submit that that's the starting point. That is, the starting point is what the Constitution says. The Constitution says in Article 2 that there's a 2-year clock on the General Assembly. The General Assembly has no trouble organizing itself in all the different ways it has to, in passing legislation, in doing all the other work that it does, knowing that there's a 2-year clock.
They'd have to get on their horse in the beginning of the session to get it moving, right? Because for the entire process to work its way to conclusion within that session of the legislature, they would probably need the full use of those 2 years, wouldn't they? Taking into account Commonwealth Court, us, proceedings in both chambers, et cetera.
Perhaps not. I'm not sure it would take an entire 2 years for that to happen. And if it did, then that's different. Look, this is no different from anything else. I think that's a fundamental point. And if
That is a problem, though, because it is different. I mean, there is a good argument that it's different than anything else.
well, Chief Justice, impeachment is different, and I recognize that. I differ with the question and the suggestion anyway that it's a good argument, and let me explain why. Article 2 sets the ground rules for all of the exercise of the legislature's powers. It's read into Article 3 in the context of the traditional issues in which this court has ruled on sine die. There's no reason why it's not also read into Article 6. Look, could a 19-year-old member of the House vote on impeachment? No. Well, one might say Article 6 when it talks about the House, doesn't say anything about the powers of what the age requirements are. That's because read into all of the business that's conducted by the legislature are the limits of Article 2. There's no selectivity at all. There's no theory of constitutional interpretation that allows that. There's no case that I'm aware of that holds that. The case that the respondents, I think, hang their hat on, the Greist or the Greist case, that's actually not a case about Article 2 and Article 6 or Article 9 of the amendment power. It's actually talking about a conflict between a separate one. Article 3, which has to do with the carrying out of legislative business and other business.
Counsel, can I ask you the flip of Justice Wecht's question? If the impeachment doesn't die at the end of the second term, when does it die? I mean, can the Senate hear an impeachment 5 years after the now defunct House of Representatives has disbanded?
Well, if I understand Your Honor's question, under the plain meaning and the text of the Constitution that I'm advocating, at the stroke of midnight, November 30, they die. Now, if there's a will to impeach Larry Krasner, that process can start again in the House. So it's not a forever prohibition and bar.
But there is no inherent termination point if it's not the sin and die.
Yes, Your Honor, if I understand Your Honor's question, under the theory that the respondents are advancing, there's no end to the time period in which that can take place. Absolutely, Your Honor. So the
Counsel, can I again? I think the sine die question is a little bit closer to something that we maybe should decide now. But again, I'm going to push you on whether there's a legislative resolution to this that doesn't involve the courts. If the new session of the House doesn't have the will to impeach Larry Krasner, why couldn't the new House pass a resolution that revokes the impeachment authority or revokes the articles of impeachment or doesn't fund or authorize the impeachment managers to continue the trial? That, again, will prevent us from having to get involved in an Article 6 matter.
Well, no doubt we'd probably hear a theory that the House has acted, and they're done. And the Senate's already taken it up. It's in the hands of the Senate. The House can't unscramble the egg that they have scrambled. And so it's too late for that to happen. It's already in the hands of the Senate. The Senate was already beginning
Well,
to
the House
think
could
about
not
the
show
issues.
up. The House could choose not to show up at the trial and not prosecute it.
Well, I'm not sure
That would take a majority will of the House.
I'm not sure that there's any contention or position that the now minority members of the House would not show up. There's no basis for concluding or thinking that that would actually happen. The arguments that the respondents are making on this sine die point, they say, well, it's happened all the time. There are multiple instances in which there has been the carryover from the House to the Senate of an impeachment outside of it. Well, there's never been a judicial challenge. It's a little bit like saying, well, people are routinely running the red lights. It's against the law, but it's not against the law because no one's been brought before a court to be held accountable for the speeding. So that's not really an argument. They also point to the federal model, and they say, well, it's happened in the federal system. Well, there's a really important difference in the federal system, and that is they don't have this carryover provision that you all have, that we all have in Article 2. And the reason, I think, significantly is that in the federal system, because senators are elected every 6 years, at the end of a 2-year period, 2/3 of them are still there. So it continues. The body continues. That's not the case here, where in the Commonwealth of Pennsylvania, there's a 4-year period for a senator. There are efforts to look at the the experience by looking at various other texts, the Legislative Procedural Manual, the Senate Rules, Mason's Manual. Each of those, as our brief points out, well document and well demonstrate that there is no basis for the respondent's opposition to our position. If I may return now to the misbehavior in office, and if I could just emphasize, you might say, well, why focus so hard on the misbehavior in office issue? I think because it so cuts at the core of the democratic process in the Commonwealth of Pennsylvania and the respondent's position that it means anything a majority of the House intends it to mean.
Isn't that what the old saying is, that high crime and misdemeanor is whatever the House says it is? I mean, isn't that...
That is an old saying with respect to a different constitution, number one. Number two, it's not a great model. There are all kinds of efforts now to be talking about impeaching people for all kinds of things, and it's very destructive and corrosive on the federal level. Justice Robson, imagine what the respondent's theory of the case would mean. On one level, it would mean, and I'm going to abstract it away from Larry Krasner and the City of Philadelphia and district attorneys. You have a Democratic majority in the House. You have a Republican governor who appoints a Secretary of Education who's got policy views about choice, about vouchers, and the House Democrats don't like it. So they go impeach him. That's not a lawful process.
But the impeachment itself does not remove that person from their position.
The conviction does.
Right, which you need 2/3 of the Senate to get a conviction.
The fractional difference is no safeguard. It's no different, frankly.
Well, it's the safeguard that the framers put in the Constitution.
But it's a zero safeguard if the standard is anything anybody wants it to be. Look, Justice Robson, suppose when you came into office, you didn't retain any of the prior law clerks for the person who was before. And suppose you wrote an opinion, whether it was on a controversial topic or an uncontroversial topic. And the House majority didn't like it. And so the House would start impeaching you. And you couldn't say, well, I was doing my job. I was writing an opinion that I thought faithfully carried out my duties and the law. That's a so what perspective under the theory of the the respondents. The respondents here are saying, we can just toss you for any reason we want.
Look,
and the fact that it would be a majority or 2/3 is no safeguard whatsoever.
I hope you're being a little bit cynical, that because there's a lot of safeguards in our Constitution to prevent that from happening. First of all, if the voters want to if they elect a state representative that is making those kinds of decisions, the remedy in the Constitution is to vote them out. That's the first Second safeguard is 2/3 conviction in the Senate. That's hard to get. Even in Pennsylvania, that would be hard to get. And then maybe a third backstop is after the Article 6 process is over, given our precedent in the Dauphin County grand jury case, maybe then a court could look to see if there was some sort of exercise of a constitutional power. But again, I go back to, you're making very good arguments. I'm not saying your arguments aren't good. I'm just wondering, why should we inject ourselves at this time in a process that should be going on exclusively in the General Assembly until at least the General Assembly has the opportunity to finish that process. And then maybe if we have to clean something up, we clean something up. Everything that you're advancing here is things that you could argue in front of the Senate, and that the Senate may very well agree with you.
Well, there are multiple layers, Justice Robson, to what you've outlined. The first point, that there's a check because the voters may vote a representative out, is frankly highly tangential.
Well, you may not, look, counsel, you may not like what the framers put in the Constitution. You may disagree with it, but that's what the Constitution provides: a majority of the House, 2/3 of the Senate. And the voters are the people that elect these people.
The Constitution does not say that it's up to the representatives to have their own theory about misbehavior in office. That is a direct assault on the role of the judiciary and judicial independence to have that view. It is a direct challenge. The notion further that we could just wait while after all the damage is done.
What damage has been done?
What damage is, there's a cloud over the City of Philadelphia's chief law enforcement officer.
Is he still doing the job?
there's a conviction. I think we're talking
There is no
about-
conviction.
No, the impeachment is a
Okay,
cloud.
Justice Brobson asked a question or stated that we could clean this up after the fact. I don't know how that would happen. A conviction on the articles of impeachment is not appealable. Am I correct?
Oh,
When would we clean it up? I mean, isn't that the predicate for being here right now? I mean, if it's not cleaned up now, there's no, I mean, maybe King's Bench, but there'd be a good argument that, I mean, the Constitution is clear that it's not something that's reviewable. So when would we clean it up after the fact?
yes, without waiver of someday arguing that there would be that opportunity, I would fully embrace Justice
It's not
Donahue your
appealable.
point.
I mean,
Well, but if the conviction by the Senate is not appealable, then the articles of impeachment aren't appealable from the House.
No, I think the point is.
By the way, this isn't an appeal. You filed an original jurisdiction action in Commonwealth
Right,
Court.
a declaratory judgment
So there is no appeal from either of these, but you asserted the Commonwealth Court's original jurisdiction to challenge a governmental action. Presumably, you could do that equally in challenging a Senate conviction as you have done the passage of articles of impeachment. Presumably.
I think my primary point is that right now, under this court's jurisprudence of standing, of ripeness, there's ample basis for concluding that Larry Krasner has a basis now for filing the action that he did
And
because of the damage.
And just so we're clear, this is not just about District Attorney Krasner. If we say that this is okay, in the future, after articles of impeachment are filed, you immediately get a right to go to the courts, to jump out of the legislature and go to the judiciary and file a motion to dismiss, which is essentially, that's the principle at play here. It's not about Larry Krasner.
Yeah.
It's about whether you can, between the articles of impeachment and trial in the Senate, you have a remedy to go to the courts to get a motion to dismiss.
And I would say yes, particularly here where the legislature has so thumbed its nose at the Constitution. Absolutely. Absolutely. The Constitution has guardrails that stop the kind of rogue conduct that the House has engaged in.
But
Look,
counsel, can I get back on the track that I think you're on? I mean, this court has the inherent authority, responsibility to interpret the Constitution. Aren't you asking us to interpret the phrase misbehavior in office? Because if you're asking us to look at the individual articles of impeachment, I think you're in the wrong place. I mean, if you get to that point, you're in the Senate. But I thought you were here asking us to interpret the Pennsylvania Constitution's phrase misbehavior in office. And I thought your argument was that was a phrase when the constitutional language was adopted that had a known meaning. Is that correct?
yes, absolutely. In 1966, when the phrase misbehavior in office was put into the Article 6, Section 6, it replaced the phrase misdemeanor in office, and the evidence is it was designed to bring together the adjacent provision on removal. The difference between the two is effectively that in the context of removal, the prerequisite is a conviction by a judicial body, while in impeachment, the prerequisite is an impeachment by the House. But they were to be interpreted together. They had the same meaning, misbehavior in office, which was the common law crime. And absolutely, it's...
The answer, I mean, it had a meaning, a common law crime. I don't know,
Yes.
I don't know if that's right or wrong, but
Yes.
I mean, it's either that the people intended that it has that common law meaning, or the people intended that it could be whatever the House wanted it to be. I mean, there are two options, are they not, in interpreting this language in the Constitution?
Yes, and if the framers wanted the provision to be anything the House said it meant, well, it could have said that. It could have said any reason. But it didn't say any reason.
Counsel, assuming we agree with you on the definition of misbehavior in office, where do we draw the line? Are we employing some kind of sufficiency analysis? What's the test the court should apply in measuring articles of impeachment against that phrase? And I'm most interested in the application of that phrase to Article 6 of the Articles of Impeachment, the Victims' Rights Statutes.
So I think, Justice Wecht, that the standard that's imposed is akin to a motion to dismiss. That is, if you look at the four corners of the article of impeachment, you ask the question, once you have defined misbehavior in office, and if you will allow, I will assume it's the way this court has done it in the context of the removal provision, the question is, well, if you look at the article and you read it, does it fairly allege a violation of, that is here, does it allege the violation of a positive, that is the failure to engage, to do a positive duty that the prosecutor is required to do? Or is there the exercise of discretion for some corrupt or improper motive? So I think that's the first part of your question. Now, let's look at Article 6. Article 6 flunks, by any measure, that test. Article 6 is entitled Misbehavior in Office in Nature of Violation of Victims' Rights. You would think, therefore, that to state a claim, there would need to be allegations that Larry Krasner, that there were statutory rights or some rights of victims that Larry Krasner violated. Now, the first thing I think that's obvious when you look at Article 6, and if you'll allow just one moment, let me have it in front of me as well. I see that you have it. The first thing you'd see when you look at Article 6, it actually doesn't allege any statute that imposes obligations on Larry Krasner or the DA. As we've shown in our brief at page 30, note 31, page 56, that the various sections that are identified here are not duties of the prosecutor. So that's failure number one. Failure number two is there's no allegation here that Larry Krasner did anything out of some corrupt or improper motive. Moreover, it actually looks like what's really being alleged is not that Larry Krasner did this, but that others in his office did it, and that it was people in his supervision. Because after all, and I will take my leave here and add an argument, which is, you might say, well, Mr. Summers, if you look at one of the previous articles, I think it's Article 4 about Wharton, that actually implicated the victims' rights, but that didn't involve Larry Krasner. There are people in his office that haven't done it. And the one thing we should all understand and agree is there's no vicarious liability theory of impeachment. We address that in our briefs. So it doesn't really address a Larry Krasner act and failure. But there's more, Justice. There's more. In what case does Article 6 allege that Larry Krasner or his office didn't respect the victim's rights? It doesn't identify a case. It doesn't identify a time period. It doesn't identify in what ways, supposedly, these were violated. This is 17 lines.
It's very spare. Suppose undoubtedly Article 6 is spare. Suppose your opposing counsel were to say that the solution for that is a motion for a bill of particulars in the Senate. What would you say to that?
I'd say that the House of Representatives had before it something that was fundamentally deficient. And when the House reviewed it, that was the time for there to be some bill of particulars or for there to be some presentation so that there could be some adequate opportunity to address this issue. This was rushed through on something gossamer thin. Now, while we're on the articles, just so there is no mistake, if one goes through and looks article by article, what actually you would find is it underscores how there's a failure to allege misbehavior in office. And you don't really need to go initially beyond the first page, because the first page and the second page, I think, say misbehavior in office does not mean the common law crime of misbehavior in office. That infects the whole thing. It kicks it all away. That's number one. Number two, interestingly, for the first time in the Supreme Court, later in the briefings, there were efforts by the respondents to say, hey, well, actually, if you look at the articles of impeachment, they do state a basis under the common law crime of misbehavior in office. As we argue in our brief, that is a waived argument. It was never argued below. It was not argued initially in these papers, and it's not fair game to be addressed.
Counsel, but if we interpret that phrase to mean the common law crime of misbehavior in office, and it goes to the Senate, that it's not waived. I mean, they could make that argument to the Senate.
The Senate,
to me, getting into the weeds of precisely what are the impeachable offenses goes beyond what I'm comfortable doing. However, deciding what misbehavior in office means, to me, fits squarely within the parameters of what we as the Supreme Court of Pennsylvania are responsible for doing. So I don't see that argument as waived because I don't see as how we would ever get to it. It would go to the Senate once we define what misbehavior in office means, whatever that is. And then it would never come back again because then there would be a definition of what misbehavior in office is. So we'd be out of it.
Justice Donoghue, if everybody had your view, then I wouldn't argue individually that the articles of impeachment fail to state a basis. Sitting here today, I don't know what your colleagues think, and I know they are trying to argue that the articles of impeachment do state a basis for misbehavior in office, and they've spent a lot of ink doing what.
Well, that's because that's what you brought the case. You went to Commonwealth Court, and you argued that what was alleged in the articles do not amount to misbehavior in office, and therefore you sought dismissal of them. What Justice Donoghue was proposing to you is sort of just a simple declaration of what misbehavior in office means, and then you go away. But that's not what you asked for in your petition for review. You want a grand slam. You want the court to define misbehavior in office the way you want it defined, and then evaluate all the counts in the articles and the articles of impeachment and rule on whether they meet the court definition. Justice Donoghue is proposing something different to you, which is, why don't we just define it and you litigate your other issues in the Senate?
Two notions. One, we're just asking what we asked in front of the Commonwealth Court and what the Commonwealth Court did. So there's nothing out of left field about the request. That is, the first page of the articles of impeachment thumb their nose at the misbehavior in office definition. That's enough to kick all of the articles of impeachment away. That's number one. Number two, the Senate is not composed of a bunch of lawyers, let alone judges, nor is the House. they're not institutionally in the position or accustomed to ruling equivalently on motions to dismiss. And three, the damage is done. That is, the impeachment has occurred, and so it can't be undone by a lack of conviction, by a non-conviction. That doesn't undo an impeachment. All the time one hears in other contexts about a president of the United States who's been impeached, and he's been impeached, and he's been impeached. He wasn't convicted, but that doesn't stop people from trying to stain the reputation, the effectiveness, and here it's the ongoing effectiveness of the City of Philadelphia Chief Law Enforcement Officer by putting a cloud over him by saying he's been impeached. So we're actually about promoting a world where there's institutional competence, where this court and courts don't shy away from interpreting the Constitution. It's an important role.
Well, that I agree with you entirely. But you're asking us to do more than that. You're asking us to define what the phrase means and then apply it to the articles of impeachment. To me, they're a different, fall into different categories. And, obviously it's going to be this way, but I mean, your opposing counsel is of the view that this is a purely political arena. And they may be right after there's constitutional definition to those terms. You're trying to shoehorn this into an adjudicative / court-like proceeding, and I just don't think that is what is part and parcel of the impeachment articles in our Constitution. I mean, there is a level after the Constitution has definition that it takes on the political process robe, in my view.
Okay. The Constitution says if the House is going to impeach, it needs to conclude that there was misbehavior in office. I think we'd agree on that. Now, there's a set of articles of impeachment that the Commonwealth Court concluded did not provide a sound basis for impeachment. And a central reason, without going through all the individual ones, is that the articles of impeachment themselves say, House members, you can go impeach Larry Krasner even though he didn't engage in an impeachable offense, even though he didn't engage in misbehavior in office. That is fatal. And it's frankly also easy for the court to declare. It doesn't require going through all the individual articles of impeachment. I think that's an important fundamental role for what the court should do. Now, is there interest in me addressing, I understand Justice Donahue's suggestion that I not address any of the other individual articles. I'm happy to briefly go through those and point to what are really a fatal set of other impairments.
You should take this opportunity to give your robust, full argument.
Article 1. Article 1 asserts a set of disagreements about policy. It charges that misbehavior in office by Larry Krasner was because he terminated 30 ADAs when he went into office. That's a personnel decision. That's like firing your law clerks. That's no basis for misbehavior in office. It charges he engaged in misbehavior in office because he withdrew from the Pennsylvania District Attorneys Association. It's not misbehavior in office. The House majority thought that, Larry, you shouldn't train new ADAs with this subject matter. You should be doing that subject matter. That's a policy difference. Look, we get that there's a difference in approach in the enforcement of the laws by the out-of-town General Assembly as compared to what is the preference of the citizenry of the city of Philadelphia. You know, the article of impeachment lambasts Larry Krasner for increases in gun violence. Now, put aside details like the absence of any causal relationship between what the DA does and gun violence. Think about the way the city of Philadelphia voters look at the hypocritical act of that. The General Assembly has prohibited the city of Philadelphia from regulating guns. And so Larry Krasner's a straitjacketed district attorney because the out-of-town General Assembly says that the city of Philadelphia can't regulate guns, and then is turning around and saying, you've engaged in misbehavior in office because there's a rise of gun violence. And to top all that, if you look at a sector-by-sector examination of where Larry Krasner's support comes from, he's got as high as 80% support in the areas that are most afflicted by the gun violence. That's because they actually think Larry Krasner is. My point is not to debate the merits of that evidence, but rather to highlight this is all about policy differences, not about an absence of fulfilling positive duties or corrupt motives. I spent more time on that one than I will the others. I'll move more briskly. Article 2, misbehavior in office and the nature of obstruction of House Select Committee investigation. A subpoena is served on Larry at his office. He does what anybody does who wants to challenge it. He files an action in the Commonwealth Court testing the subpoena. That's not the failure to exercise a positive duty or corrupt behavior. That's following the law. It's actually another example of the House majority thumbing its nose at the courts. We have courts to do what Larry Krasner is suggesting. The notion that that would be in misbehavior in office underscores the malignancy of these articles of impeachment. I'll take Articles 3, 4, and 5 together because they all suffer from a couple of common things. Number one, with the exception of the last one, they allege conduct not by Larry Krasner. They allege the conduct of people in his office. So they don't begin to, they have some vicarious theory, liability theory for impeachment. Moreover, they don't allege the breach of any positive duty, any statutory duty, nor do they allege improper or corrupt motive. What they allege on their face is the violations of the rules of professional conduct and the canons. And under this court's well-recognized precedent, and as the Commonwealth Court recognized, that's in the jurisdiction of this court. Now, if these articles of impeachment alleged some violation of a Title 18 statute, that'd be one thing, but they don't. They allege, they usurp what you all are here for. They usurp the whole organized disciplinary process in trying to sweep it in to the scope of the articles of impeachment. Article 6 we covered. Article 7 I've essentially covered already. That alleges the misbehavior in office and the nature of violation of the Constitution by usurpation of legislative function. Now, that's a head scratcher. They don't allege the breach of any statutory duty, nor do they allege an illegal or improper motive. Moreover, the theory, the construct in Article 7 collides completely with the notion that this court has repeatedly recognized, namely that a district attorney has extraordinary discretion in what she or he is going to prosecute and not prosecute.
A policy decision that they are not going to prosecute crimes that have been enacted by the General Assembly.
I think,
Isn't that misbehavior?
I think, Justice Mundy, a sweeping statement, I'm not going to prosecute crimes, is the failure of a duty. It's a basic abdication. But that's not what's alleged here. What's alleged here is that there are some categories of crimes that he is not as vigorously prosecuting as others. And that's a far cry from Your Honor's hypothetical.
Well, if I can follow up on that question. Of course, we don't have the extreme, and couldn't imagine the extreme where an elected DA would say, I'm not going to prosecute any crimes. But is there a tension between the robust and well-respected discretion of a prosecutor on the one hand, and the language failure to perform a positive ministerial duty of the office if an elected prosecutor says, with respect to this section of the Crimes Code, I will not bring cases under this code section, period. In other words, it's not a blanket across the whole Crimes Code, of course, but a blanket statement or policy about a particular offense or set of offenses. Is there a tension there, and how would, if there is, how would you resolve it?
I'm not aware of a statutory duty, which is what misbehavior in office requires, that says a prosecutor is prohibited from exercising his discretion with respect to some discrete categories of crimes. That I'm not aware of as a basis, and the respondents haven't cited a statutory duty that says that.
I guess if I could make my question more concrete, I'm not sort of putting the bunny in the hat. I don't have a presupposition on this. I'm just asking if a prosecutor says, possession of a small amount or shoplifting, whether it's under larceny or theft or whatever, these code sections are not going to be prosecuted by this office. So it's not a discrete, that with Jones we're going to take a knee because he's circumstances in that case, but with Smith we're going to bring the prosecution. Brown will talk about it, maybe bring the case or not. It's that all of these, say, possession of a small amount, as an example, but you could think of other code sections too, we're just not going to bring them. Is that a hypothetical that could bring you over the line on failure to perform a positive ministerial duty of the office, on the theory that it's a positive ministerial duty of a DA to bring at least some cases under each section that the General Assembly has put in the Crimes Code?
I think, Your Honor, that it goes to the breadth of the hypothetical. And what I mean by that is, if there is such an extensive stepping down, whole swaths of many crimes, then that may well be verging on a kind of complete abdication of the responsibilities. And so it's at the extreme level that may be the case. We've looked for statutory duties that could be implicated by precisely this. And, we found 16 PS 9952, which imposes a duty to sign all bills of indictment, to try cases in the name of the Commonwealth. That's really the kind of ministerial duty that a district attorney has. And selectively identifying small categories of crimes actually that are being looked at on a case-by-case basis, not necessarily categorically, That fits within the discretion of what a prosecutor's there to do. It's akin to charging decisions. But Justice Wick, I don't mean to duck your hypothetical. I think one could find a polar extreme, nowhere near what's in these articles of impeachment, that would amount to a kind of complete abdication that would be problematic.
Well, just to follow up on that, there is the oath of office, and there is an oath that the elected district attorneys take to uphold the Pennsylvania Constitution, which, and as you have indicated, District Attorney Krasner and the district attorneys are the chief law enforcement officers. If the General Assembly passes a law and the governor signs a law that says certain conduct is a crime, and a district attorney says, yeah, but I'm not charging that crime ever. I think Justice Sweat gave you an example, which is, I am not going to charge anybody who steals, shoplifts from a store if they take less than $1,000 worth of merchandise. You don't think that's an abdication of the obligation of the district attorney to enforce the laws of the Commonwealth of Pennsylvania under the Pennsylvania Constitution?
I don't think it's a violation of a statutory ministerial duty that fits within misbehavior in office, which I think is the precise question as to whether it's an impeachable
So
act.
statutory duties have greater precedent than constitutional duties.
The law is ministerial positive obligations, and a individual instance in the portfolio of a prosecutor's entire discretion in charging and what laws to enforce.
Well,
no, I don't think it is.
I think
No.
that's interesting that you separated those two, between what to charge versus what laws to enforce. You believe that the district attorney has the discretion to choose which laws passed by the General Assembly the district attorney will enforce and not enforce.
Well, I think the district attorney has within his discretion the ability, again, let me reframe. The question is whether something's an impeachable offense. The question is not whether he should do it or he shouldn't do it, whether he should be voted out of office for or for not being voted out of office. This is a district attorney who ran on a reform agenda, who said, I'm going to take a hard look at whether I'm going to prosecute people for certain sex crimes. I believe was actually one of the things that was sex workers early on. And the people in the city of Philadelphia said, we want this guy for a set of reasons, but presumably that was one of the policy things. I think that kind of careful and modest selective enforcement is within the discretion of a district attorney and is not the violation of a duty.
Yeah, could I just follow up? I mean, I think that's sort of, that's pretty easy. That's declination is well within an elected prosecutor's discretion. I was trying to pin you down on a categorical thing, but the articles, as I understand it, I mean, I guess I suppose you're maybe taking a harder line than I anticipated you had to take on this, because you seem to be, if I'm not mistaken, you seem to resist a concession that would say a categorical stated policy of never prosecuting a particular crimes code section might amount to misbehavior in office. You seem to resist that when that's not even, as I understand it, been alleged. Am I missing something?
I agree it's not been alleged, and so I'll go with you on that, Justice Wack. I think it depends on context. If the single crime is murder, okay, I'm not going to prosecute murders. That, in context, that feels like the kind of thing that could be the kind of application.
It shouldn't matter in theory, right? It shouldn't matter from the perspective of the General Assembly. If a prosecutor, an elected prosecutor anywhere in Pennsylvania, looking at Title 18 says, you know what, this section or that section or these three sections or what have you are just code sections I refuse to enforce, or I refuse to charge. Any categorical statement, you know, by hypothesis, the grading or the identity of that code section shouldn't matter to the constitutional question, should it?
I think it goes to the materiality of what we're talking about. And it's the materiality and the scope of what you're referring to as abdication. And so there are a lot of crimes in the crimes code. And so you look at whether he's essentially not fulfilling the function of the job, which where you would look at the scope of what it is categorically he's not doing. And so if there is a narrow categorical component, then I think that's a different question.
Mr. Summers, hypothetically, if District Attorney Krasner had said, I decline to prosecute vehicular homicide cases, I'm not gonna look at them, would that be misbehavior in office?
I think given the seriousness of the offense, objectively, I think that would tilt towards that possibility. But we don't have anything like that here. And I think that for the purposes of today, and in Justice Donahue defining what misbehavior in office is, I think we are well positioned to be saying misbehavior in office means what the court said repeatedly in Section 7 of Article 6, that is the failure to fulfill a positive duty or the exercise of discretion in a corrupt or improper way. You know, the respondents would have the court believe that that standard that I just said is judicially unmanageable. Well, y'all do that all the time.
That's why I keep that's
Yeah.
that manageability question is why I keep trying to I'll just try one more time with you.
That's right.
If I'm a DA and I nullify a code section that the General Assembly has passed by saying I'm just not going to charge this, ostensibly that could be failure to perform positive ministerial duty of the office without reference to judgments about whether it's a more or less severe criminal offense. It either is a categorical nullification of a legislative enactment or it isn't. I mean, it hasn't been alleged here. This is hypothetical, but yeah. I'm just trying to discern what the limits of your argument are, and it seems to me you want to import a qualitative assessment, which I don't know how that's judicially manageable if the 6 of us or 5 of us here right now were to say, in some case, this is a sufficiently severe enough code section that we're going to judge his failure to charge it impeachable, but this one isn't that important. I don't know where the discernible limit on that argument is.
All right. First of all, Justice Weck, thank you. This is your third go at me on that.
I'll stop.
No, I'm not discouraging it. I appreciate it. I'm feeling bad that I haven't satisfied Your Honor, and I think my approach is this. You all are a common law court, and as a common law court, not a civil court, you might make a broad pronouncement about a standard, and then it's over time, as individual cases present itself, you flesh out the meaning of these things. So it's not for this case to say whether a categorical decision not to prosecute constitutes the failure to exercise. I think, just as the court all the time would, as individual cases present themselves, make judgments about, look, whether a doctor's negligent or not, okay? You don't, in the first instance, define all of the ways in all the specifics for what the negligence standard is all about. You do it as individual cases come up. And I submit this case is no different from that, not this case, but this problem. And the problem, Justice Weck, that you are continually asking me to address. And I think the best answer I can give to you is that for the purposes of this decision, you can, as Justice Donahue said, announce a rule. The rule is one that is profoundly not what the House did, so strike the articles of impeachment without addressing that, and leave to another day the evolution of the decisions about whether a specific declination that's categorical constitutes the violation of a positive duty. That's in the DNA, it seems to me, of what this court is about and what it does.
But what you just described is this court playing a role in every impeachment proceeding.
Well,
I don't see that happening. And let me just, to me, separating the performance of a positive duty from the exercise of discretion is a little like angels dancing on the head of a pin. And I mean, if a district attorney decides not to prosecute a certain category of offenses, but the reason is because it takes 80% of her prosecutors, and consequently other crimes are going unpunished or untried. That's an abuse of discretion question in my view. That's not a categorical refusal to do anything. And I venture a guess that Mr. Krasner has policy reasons that may be attendant to the facilities of his office that support what he does and does not prosecute. But see, that case would be made before the Senate. I mean, that issue of whether or not there was an abuse of discretion in that context, and I'm just going to get back to it one more time. I don't know how that ever gets back up to us.
Okay.
I mean, so, and I understand your argument. I mean, and I could be way off base on this, but at some juncture, the way the Constitution is designed is that this is a political process in some part. It has to be fair. It has to be fair. You have to give definition to terms of the Constitution, et cetera, et cetera. But once that's done, it's in the hands of the General Assembly.
Let me address a couple of points on this behavior office, including yours, Justice Donahue, and Justice Brobson, I think a concern you raised. The more you dig into this controversy, the more I think you'll find, thank goodness, impeachment's really a pretty rare event at the moment in the Commonwealth of Pennsylvania. So one worry I think we don't have, or shouldn't have to have, is some floodgate notions that there are going to be impeached parties that are going to be running to court all the time to clog up the courts or interfere with the process that's contemplated in Article 6. This is a really quite rare event. And let me just underscore and acknowledge one of the things that the respondents and we agree with is there has been no Pennsylvania Supreme Court definition to misbehavior in office in the context of Article 6. And I would submit the first reason is because, thank goodness, this is not a weapon that has been oft-used. So I think the concern that there will be this constant rushing to court and the disruption of the process is an illusory one. It's not a real one.
I'm intrigued by that argument because your initial argument when we got here was we have to step in because impeachment is being weaponized in politics and the federal level and at the state level, and now you're saying, no, there's really no risk to that.
Oh, to the contrary, Justice Brobson. What I was remarking on was that this impeachment in 2022 is a watershed moment for this Commonwealth. That is, we now have a House of Representatives that thinks we can just make it up and decide, and maybe the Senate, we can just impeach people for any reason. Okay? That actually wasn't the law. And the history of impeachments had been that it's been for people who've engaged in corrupt conduct.
So you're saying this is just a one-off because this particular session of the House went crazy?
Well,
there's
I
no future
I would
risk.
be the last to use words like crazy.
Well, there's no
I have
future
too much
risk.
respect. I have too much respect for other branches
Understood,
of government.
but that was my word, not yours. But there is no risk that this is going to happen again.
I would not agree with that at all. I think that you would be greenlighting this kind of lawless activity that fails to respect the rule of law, that thumbs its nose at this court, if you allowed the impeachment as it happened to stand. And the notion that it could be later cured is no notion whatsoever because of what has actually happened.
Would it necessarily mean that if your argument is correct, by implication, wouldn't it also be constitutionally troubling that a prosecutor can get a grand jury to indict a ham sandwich? So to say that the fact that a grand jury will return a true bill if the prosecutor wants it 99 times out of 100, ought that also to be constitutionally worrisome if your argument's taken to its logical conclusion, because it can't be remedied at the trial?
I think I agree with you. That is, that just as it should be unlawful, prohibited, and not allowed to have a prosecutor charge not in accordance with the law, and that should stop the proceedings, and it's not for a later day to test that, which is why we allow the testing of a grand jury of an indictment immediately. It's to stop someone from having to go through a trial. Look, the impact of waiting till later is to require Larry Krasner to go through a whole trial. That's an enormously distracting,
You don't
dangerous
know that.
activity. I don't.
I'm
I'm his lawyer.
I'm sorry?
I'm his lawyer. I do.
Well, but the Senate, as I understand, at least as I saw in the briefings, the Senate has set forth a committee, processes, procedures. There's nothing that you couldn't file a motion to dismiss or put in front of the Senate some kind of a motion that says, we want you to decide now before trial that these charges do not amount to what the Supreme Court has decided to be a misbehavior office. There's nothing preventing you from doing that.
Yes. One, the articles of impeachment say he can be impeached not for misbehavior in office, as this court has done it. So it's done. The Senate isn't going to sit there and say, oh, gee, we're going to now take a different view from what the articles of impeachment are. Two, they're not judges and lawyers who have the same level of institutional competence to do the interpretations of constitutional provisions. Three, this court has a great tradition of not being reluctant to uphold voting rights, the election results, free and fair elections, in other closely related
that led
contexts.
to the introduction of articles of impeachment against one or more, ironically enough.
There are many.
I don't know which way that cuts here, but
because it means that this court has not shied away, as frankly the suggestion that's being made is that this court shouldn't intervene, shouldn't be giving views, shouldn't be expressing views, shouldn't be stopping this now dead in its tracks. This is a fundamentally anti-democratic.
Where did we stop? I think I can't accept your analogy. This impeachment process is completely different from someone bringing an original jurisdiction action to challenge existing legislation and challenging it as unconstitutional. This is an Article 6 process, and the courts are not mentioned at all in there. And I disagree with you about me suggesting that my questions are somehow suggesting that I am shy. If anybody on this court knows, and anybody who's been in front of me, I've never been accused of being shy. What I am shy about is injecting one branch of government, just as I would not want the General Assembly to stick its nose into a court proceeding. I am shy about whether it makes sense constitutionally, jurisprudentially, for us at this stage to stick our noses in an Article 6 process. That's what I am shy about.
The law, Your Honor, about political question doctrine notions of whether we defer to other branches of government, and this Commonwealth has its own well-developed jurisprudence, asks the question not whether we're abstractly reluctant or not. It really is well-defined. Number one, and principally, does the text of the Constitution delegate to the other branch of government, not this court, the role of interpreting the relevant provisions? That's essentially what that doctrine holds. The not getting involved, Justice Wecht, as I think Your Honor pointed out in a recent decision, why that getting involved is judicial review. It's been around since Marbury versus Madison. It's the exception to not step in. And there's nothing in the text of the Constitution, in Article 6, Section 6, that says judges stay out. All of the provisions of Article 6 don't say anything about the court shouldn't be involved. Yet the court's involved all the time in interpretations. Let me, if I could, refocus briefly with respect to a textual argument that I don't want to miss, because I think my good friends who represent the respondents may argue, and I want to make sure it's addressed.
That's fine, and then I'd like you to sum up.
Okay, then there's a third issue, which is the civil officer issue, and then if I could conclude. The respondents argue, well, Section 6 allows for impeachment for any misbehavior in office, while the removal provision calls for removal on conviction of misbehavior in office. And they note, well, one provision says conviction, and the other provision is any, and therefore therefore misbehavior in office can have the different meanings that they're advocating. I can't think of a theory or practice of statutory or constitutional interpretation allows that. Let me explain why. And I'll take each of the words. The role of conviction in Article 7 is just a statement that there's a prerequisite before removal, which is a conviction in a court. And the prerequisite in Section 6 isn't a conviction. It's an impeachment. So that's why Section 6 doesn't have the word conviction, and it sheds no light on the meaning of misbehavior in office. Let me move to any. Any misbehavior in office versus misbehavior in office. We know at least two things. Let's take their theory. What construction of the word any allows the following? If something prohibits misbehavior in office, it means failure to do an affirmative duty or the exercise of discretion with a corrupt motive. But if you insert the word any in front of it, it no longer means that. That meaning goes away, and instead it means nothing. It means anything the House of Representatives or the Senate wanted to mean. There's no definition, no meaning of the word any that has that possibility. Think of the following analogy. Suppose there were a statute that says, no establishment shall sell tobacco products to minors. And then there's another statute that says, no establishment shall sell any tobacco products to minors. I don't think there's a court in the land that would say the insertion of the word any renders tobacco products to mean bubble gum and anything that the the enforcers mean it to mean. So I think that's a fundamentally improper argument that has no weight. Let me now turn to, if I may, the third issue which we've raised, and I want to do this briefly, and I will rely mostly on the briefs. Larry Krasner is a locally elected official. Article 6 calls for the possibility of the impeachment of an, quote, other civil officer. We have two textual arguments as to why he's not an other civil officer. One textual argument is other references to governor, which is a statewide officer. So in saying other civil officer, it's an other like officer, which is a statewide one. I will allow that that goes maybe to the 50-yard line, but it doesn't get you to the end zone. But I think you get to the end zone when you look in conjunction with the other part of the section, which says the remedy is that someone's removed from statewide office and from holding statewide office. And you'd have to scratch your head and say, it's kind of weird to have a DA impeached for what he did wrong in the city of Philadelphia, and the remedy is that he's not allowed to hold statewide office. So I guess he can have...
I'm sorry, I'm really jumping in, but I did want to ask this question, so pardon me for interrupting you midstream. What about the fact that historically there have been several common pleas county court judges that have been impeached?
I think the judges are different.
They're elected by their county?
The judges are part of a unified statewide system.
No, these judges are elected by their county, the county of...
They're elected by the counties, but they're part of a unified statewide system in a way that the district attorney is not.
Although there were impeachments of judges before the unified judicial system was ratified, right? I mean, you could just argue those precedents were wrong, and that Justice Saylor's view is correct.
Well, look, fairness here is, I believe, for any position I'm advancing, needs to have a textual anchor, and I'm anchoring this in the text. I recognize, truly, that we have Chief Justice Saylor's opinion, which looks, in the context of removal, for a refreshed review of this issue. And he thought it was important. He thought that that civil officer, in his, admittedly not his majority opinion, but in his concurrence, had a meeting, and the four justices said that this was a cogent theory, and they didn't address that issue in that case.
And here we are.
And here we are, because now is the right moment to do that.
Suppose that argument appeals, then how would you address the argument that it would be peculiar that the framers would not then have a provision anywhere in the Constitution for impeachment or removal of county officials?
Easily. Because because they would be recognizing that in our democratic process, we have different tiers. And the statewide General Assembly has the province of removing other like statewide people.
Correct.
And the locals and all the local counties, like Philadelphia, which has an impeachment provision, okay?
They could repeal that. The City Council of Philly could repeal that tomorrow.
Okay, or they could, but it's up to the localities to decide whether they want to have an impeachment provision or not. It would make total sense for the framers to say, when it comes to impeachment, which is, look, it's really an exception to the way government should run. Okay, it's an extraordinary thing. We leave to elections differences of opinion about policies, and we leave for removal when there's like convicted folks. But impeachment should be a rare occurrence. And so it would make complete sense for the for the framers to say, we'll step back, and when it comes to what we
Morning, Chief Justice Todd, Justices. I'm Corey Woods, and I'm here today on behalf of Senator Jay Costa, who is the Democratic leader in the Pennsylvania Senate. We're here, and we've presented arguments on what I think is the narrowest and the most clearly justiciable issue, whether adjournment or lapse by operation of law of the General Assembly terminates all legislative business, including impeachments. The best opinion would be one that gives us a definitive pronunciation of sine die or sine die or sine die.
We weren't sure how to pronounce it, or I speak for myself.
But I think that given how far we've come so far this morning, I'm going to jump right into the deep end on this issue of lapse. So before we talk about the merits, as I said, I think it's the most clearly justiciable issue. It is different from the other two in that we're talking a little bit less about what's going on internal to an impeachment proceeding and more about whether this body has authority to do this at all. It's our position that just like the Senate of Nebraska cannot try Larry Krasner, the Senate of Pennsylvania and the 207th General Assembly cannot try Larry Krasner at this point. One point I did want to raise on this standing issue and this political question issue is first of all, in addition to District Attorney Krasner's standing in this case, you have before you and my client a sitting senator who alleges that he is subject to and going to be required to participate in an unconstitutional proceeding that the body has no authority to engage in, not only forcing him to be a juror, but also obstructing the otherwise existent priorities of the Senate. The other thing I wanted to raise, and we talked a little bit about textual commitment of the power to impeach versus textual commitment of the assessment of the power to impeach, and that's the Fulton County case. I believe that Justice Weck is one of your cases. We've argued that's not here. The one thing that had kind of been bothering me is the respondent's argument based on the word soul. We want that to have some effect, just gutturally. And as I was doing my last-minute anxiety-prone research last night, I dug into the 1682 frame of government authored by William Penn, to my right, who, in that frame of government, provided not only that the General Assembly had a right to impeach, but also that he and the other members of the Executive Council had a right to impeach. Also, under the Constitution of 1776, there is a General Assembly that has a right to impeach, unicameral, and a Council of Censors that has a right to impeach, sort of a constitutional ombudsman. So when viewed in conjunction with those two previous constitutional organic documents, what sole power to impeach really means is, well, we don't have a Council of Censors anymore, the governor can't do it, and by the way, the Senate that we just created for the first time in 1790, they can't do it either. So I just wanted to get that out ahead before I started on the merits. On that subject, I think I'd like to start where we all agree. We all agree that Article 2, by creating the General Assembly, creating the members, creating their election, and creating their terms, creates a period of 2 years during which people who are elected at one election have a mandate to go and conduct the business of the people. We agree that it applies whether you're naming a bridge, whether you're appropriating money, whether you're passing criminal statutes, other legislation. What we disagree about is whether it also applies to the legislative business, the General Assembly's business, of impeaching civil officers. Is there an exception? Facially, there doesn't appear to be. Let's talk about text first. Purely text, not context. There's nothing in Article 2 that says those terms of office go on after 2 years for impeachment proceedings. There's nothing in Article 2 that says legislative business ends except for impeachment proceedings. So let's put that to the side. Let's talk about structure. Article 2 creates the conditions precedent to the exercise of the General Assembly's power. And counsel has played a little bit between the difference between legislative and legislature and authority and jurisdiction, but really what we're talking about here in Article 2 is the establishment of conditions for the exercise of anything that the General Assembly can do. Structurally, that applies in every other portion of the Constitution in which the body is referred to. So, when Article 10 about taxation or whatever it's about says the General Assembly shall have the power to do X, Y, and Z with respect to taxation under certain circumstances, the phrase General Assembly, or House or Senate, refers back to the body established by Article 2. Pretty straightforward. What we haven't talked about yet today is what is the purpose of this lapse principle, whether it's by sine die or whether it's by lapse by operation of law. What's the purpose? I would submit to the court today that here is the purpose. When we have an election and the people who are elected begin, they have new priorities or different priorities, or may. They have potentially a different composition of the body. They have a new opportunity to be the government. And for that exercise of that power to have legitimacy is predicated on the most recent election.
Can I interrupt there, Mr. Woods?
Please.
That seems like a logical and reasonable argument, except that if we don't go to that policy type argument yet and stay on the text for a minute, would you agree there's nothing in the text of the Constitution that says that the pending business must terminate?
So I would say there's not an explicit indication that the business must terminate.
And that's, and then if I can just add to that further for you to address as well, given that the framers did not, I mean, they said how long the terms are and when the entity begins, but an argument about the extinction of pending business is a matter of implication or extrapolation from statute or regulatory enactments rather than a constitutional text argument. Is that right?
So I think perhaps the word implication is appropriate, but I think it's, to me, a clear implication because whether it's a corporate body or a committee or whatever the body is, when it adjourns or it is extinguished by operation of law, its conduct is done. And we've cited the Order of Solon case in the brief that talks about a private fraternal organization, and we've cited a couple cases of this court. Brown versus Brancato, I think, is the big one that says, House, you've got an investigative committee, it's done. So I think, to me, the die is kind of written. But textually, I think the implication is, here's the term, particularly as modified in 1968 to say it's going to continue as a continuing body for that period. When you go outside that period, it's no longer a continuing body. And the implication of that is everything's done. To me, I'm sorry, Chief. To me, it's kind of like a Quaker meeting, right? We are the Quaker state, after all. When you have a Quaker meeting, everyone shows up, rules are established, people make decisions, and business is done. When the body expires and a new body is born, that mandate is gone. Anything that they haven't already accomplished was not able to pass the public mandate at that time. I'm sorry, Chief, go ahead.
No, I was just going to say outside of the odd situation of impeachment, this is a rather unremarkable proposition, and you can have a bill that the legislature's been working on diligently, and everybody wants to see it pass, but for some reason the important issue doesn't reach the table and does not get passed by the end of the year, by the end of the 2 years. It's over. That's it. No matter how much everyone wanted to see that pass, you start all over again the next term. So it seems to me that impeachment is really no different than any other legislative business, unless someone convinces me today that it is.
That's right, and I think the reason is that purpose, because when legislators are seated, they have a third of the sovereignty of the people of the Commonwealth of Pennsylvania behind them. They get to take positive actions. And if they don't take those positive actions while they have that mandate, they didn't do it.
See, that makes a lot of sense, but again, it's not in the text. And I wonder what your answer would be to the argument that since it's not in the text, the solution would be for the reconstituted body to say, you know what, we're no longer on board with that, and revoke it. I mean, it hasn't, whatever it is, it's not been presented in the legislative context, hasn't been presented to the governor yet, right? So it can still be undone by that chamber that's now been reconstituted. Given that the text says nothing about extinction of these matters, why wouldn't that be just as plausible?
Well, and if I may add, nor does the text say anything about revocation.
Right. And I think the error in that reasoning, Justice Wecht, is the word reconstitution, because the precedent of this court and the practice of my understanding of Article 2, the way it's functioned, not just in this court's precedent, but also throughout the Senate over years, hundreds of years, is that it's not a reconstituted body. This building is not the General Assembly. The individuals across the hall are not the Senate. The institution itself is the mandate. It is the collective body which is vested with the mandate of power at the most recent election. And it's not reconstituted. I don't want to get into the difference between prorogation and the dismissal of Parliament, because I think it's too far down the weeds. But in the United States, in part because we're not talking about the divine theory of kings anymore, popular sovereignty is renewed at each election and is reconstituted in a new General Assembly. That's why we're at number 207.
Mr. Woods, can I just jump, because I think you made a point which I thought was interesting about not wanting to sort of bind or impact a new body that gets to come in fresh, right? And that seems to make sense with the exercise of the legislative power. The idea, because a single house of the General Assembly lacks the power to enact legislation. It requires the conduct of both. And the idea that you would have to have the snapshot of both in the same session, considering the same legislation, even though atextual, maybe atextual, I could probably understand. Here, though, the power of impeachment is independently vested in one body. The Senate doesn't have to approve it or disapprove it for it to be effective. So what is it about once the full act of the House is done, the session goes on, or the session lapses, but the articles of impeachment have happened. They have occurred. No action of the Senate was required to affect it or to give it meaning or anything like that during the same session. Going to the new Senate, I mean, what is it that's incompetent about the new Senate to be the trier versus the competency to consider the same legislation in the same photograph?
So I would push back on the premise a little bit, Justice Brobson, because I don't think it's true that there is no requirement. I don't think the idea that the chambers have to act together is necessarily true, even of legislation. Let's say I want to name a bridge. The House says we want to name a bridge end of November. Everything that you've just said about impeachment, they say we're naming it the Justice Brobson Bridge.
Which would never happen, by the way, unless the bridge was non-functional.
You'll get one before me, that's all I'll say. But let's say that they do that. November 30th, 11:59. Their action is done. The Senate could conceivably, if session continued past 11:59, or if they turn the clock off, but that's a whole separate problem, the Senate could conceivably say, yep, that sounds good in December, and their constitutionally required action would be done. Now, in practice, generally what happens is folks downstairs disagree, folks across the hall disagree, there's a conference committee, we work it out afterward. But there's nothing constitutionally that says, well, there is, but there's nothing constitutionally different about the House passing a bill and the Senate passing the same bill as there is, than there is to the House saying, we'll charge you, and the Senate convicting you.
I'm not sure I understand your whole naming the bridge thing, unless the naming of the bridge requires legislation, because, again, a bill that's passed by the House is not a law. And for it to get to the governor's desk, it requires the action of both. And so I'll go back to compare that to the impeachment. For impeachment articles to be passed, it does not require the participation of the Senate. The Senate is not burdened in any way with having to consider them for them to be issued. The House acts alone under the Constitution. So my question that I asked you was, what constitutionally makes the Senate in the immediately subsequent session incompetent to factually try those charges, because unlike legislation which requires both to act, impeachment has separate acts, separate independent events.
I take your meaning. I think I have two responses. The first is, I do think it's a distinction without a difference, and here's why. If I want to criminalize dancing on 3rd Avenue, the House says we want to criminalize dancing on 3rd Avenue. Done. It's passed the House. The Senate says we agree. Done. It's a law. I'm sorry, it's sent to the governor, et cetera, et cetera. In an impeachment proceeding, the House does its part, the Senate does its part. I don't see a meaningful difference in terms of, and this dovetails with my second point, I don't see a meaningful difference in terms of why business expires at the end of the legislative session. Because just as there is a lapse of legislative authority, of a sovereign mandate, to say we want to name the bridge, or we want to criminalize this, the same lapse of authority occurs as pertains to the decision to impeach and remove someone from office. I see that you're drawing a distinction between the House's conduct on one hand and the Senate's conduct on the other hand.
Yeah, because the impeachment articles don't go away. Unlike a bill, which literally dies, no longer exists. At the end of the session, you're not suggesting the articles of impeachment never happened.
I'm suggesting that the business of an impeachment proceeding concludes.
You're saying that the Senate can't do its job.
No. I'm saying that the lapse of the legislative session robs the House's conduct of its legislative mandate. And now we have a new House. The people have reconstituted their power in a new House. So
under your argument, just to make sure I conclude and I understand, articles of impeachment though duly passed by the House of Representatives under its constitutional power, cease to exist, sine die, as if it never happened.
They die, right? They happened, but now they're going to die.
Precisely.
Right.
And if I can follow up, then the Senate cannot act on it because that impeachment articles no longer expresses the will of the people.
Exactly, Justice Donahue. That's exactly my position.
And textually, I thought you were going to respond to Justice Brobson with the first sentence of Article 2, Section 4, which says the General Assembly shall be a continuing body during the term for which its representatives are elected, meaning both chambers. So then by implication, what was going on before is no longer continuing and needs to be started anew. You still have the theoretical possibility I raised about, in the absence of any text saying that either chamber could come in the new session and revoke what it did before, that's another plausible reading. But let me ask you this: what would you say to the question I had for Attorney Summers earlier about the running out the clock scenario, which seems to be a real risk?
So my argument is a couple-fold. First of all, it's not what's happened in this case. I think there is one way to view what's happened in this case as the Senate decided to do something, and Larry Krasner ran to the courts and told them to stop the presses. There's no stay in this case. There's never been requested a stay. There's no injunction requested. What they've requested is that the courts say what the law is. That's this court's authority, and that's wholly proper, regardless of what's going on across the hall. The guy behind me set that up in 1803, right?
Well, and they said, and dismiss the articles because they don't rise to the level of how you would define it. But it goes a little bit farther than just saying what the law is.
What we've advocated for is a declaratory judgment that talks about the lapse and its effect on the authority of the Senate.
But in terms of the effects, as a practical matter, if we hold that they died on the vine and there's nothing there for the Senate to try, nothing is precluding the new House with its newly elected members from doing the exact same thing again, subject to any other constitutional challenges that might come before us. But just on the sine die question, nothing to preclude them from doing it again.
That's right. This is a purely procedural constitutional argument. They could do it again. And this goes back to Justice Beck's question a little bit, too. It is true that the House could use that sovereign authority to potentially to disclaim what the previous House did. But that requires a positive act, right? What I'm suggesting is you need a positive act of the General Assembly, House and Senate, within the same General Assembly to complete the action. So it may well be that there are not enough votes to impeach him now, but there aren't enough to disclaim it. I don't know that. I have no idea.
There aren't enough. I didn't hear you. There aren't enough to what?
Yeah. So it might be in between. It might be there's enough in the House to. There's not enough in the House to impeach. There's not enough in the House to disclaim it.
But you would agree that as to the democratic fury prong of the argument, such a reclamation or revocation option would vindicate the people's voice, so to speak.
Well, I don't know that it's provided for, and we really haven't briefed it because I think Your Honor's question is very thoughtful, but it's just not one we've grappled with yet.
Well, I would represent that it's not provided.
Right.
But it's not what?
It's not provided. The revocation power is not provided.
I certainly don't see anything in the text that says the House can, takes these backseas.
Well, here's what I think is complicated about this. You can go through these steps and it sounds so simple, but impeachment is a different animal, and it's a two-part animal. It's the part that goes to the House, the impeachment itself, and it's the part that goes to the Senate, the trial and conviction, possible conviction. And that does trouble me that it's different from everything else we're discussing in the sine die context.
Right. And I think I agree with the circumspection. It is factually different. But I think when you take a view of what sine die or lapse, is intended to do, which is to renew democratic authority, the fact that, with ordinary legislation, one house passes and another house passes, and with impeachment, one house charges and the other house tries, I don't think that that distinction leads to a difference in treatment as to whose authority are we exercising.
Well, but there's no doubt that the people of the last General Assembly elected a General Assembly that impeached Larry Krasner. That was a complete act that did not require the participation of the Senate, and that was the will of the General Assembly that existed in the last session.
Right, and I think what I'm saying is that I agree to your point, Justice Brobson, that it is possible to view this as two separate acts. Sure it is. But it's also possible to view legislation as two separate acts. And regardless of whether you view it as one conjoined act or two separate acts, it doesn't make a difference in terms of whether this person is present, like the will of the people presently wants this person to be tried.
Well, but you say it's a factually distinguished. It's actually a constitutional distinction. The articles of impeachment have separate independent significance unto themselves. I mean, we just heard argument from Mr. Krasner's counsel that this is a cloud hanging over his head, just simply having been impeached. Whereas one passage of a bill by the House, by one House, has no independent legal significance. It can't go to the governor. It's dependent upon the other House acting. But here, the articles of impeachment are the articles of impeachment.
That's absolutely correct. But right. It's simply he is still impeached. But the fact of the matter is, everything that the 206th General Assembly did is done. And for the 207th to reach back, or put contrary-wise, for the 206th to exercise sort of a legislative dead hand, creates some very bizarre circumstances. So let me talk about the consequences here. Justice Wecht, as I said before, I don't think that delay is really at issue here because there's been no court order telling the proceedings to stop.
But what if there were?
I'm not sure. Well, I think that's a different case.
Well, but we have to. But you're asking us to establish a simple hard principle of sine die,
Yes.
which, if we say it dies, that opens up a window for mischief. And don't we have to consider that?
I'm not sure what it means in terms of remedies, and any of those orders would be appealable to this court.
But the Senate trial has to conclude in that session too, right?
That's correct.
It's a fairly tall order to get it all. I mean, a House would have to jump on into the beginning of its session, anticipating appeals to the Commonwealth Court and this court, anticipating the Senate trial. I guess following up on Justice Brobson's question, would the ruling you favor incentivize gamesmanship and delay? Or does that even matter if we're interpreting the Constitution?
So it doesn't incentivize gamesmanship. I think it matters because it's a policy question, but I don't think it incentivizes gamesmanship on behalf of the public official at issue because he's dealing with reputational harm in the meantime. He's impeached. As we all know, over the last several years, when someone is impeached, often it causes them significant problems going forward. But I think what it does incentivize is the lame duck House, if party control is changed or certain individuals are in favor or out of favor, to say, well, we're going to start impeaching everyone we don't like. Okay? And last time, it was a Republican House who impeached someone on the way out the door, but it could just as easily be a Democratic House on the way out the door. There are thin margins in the House. And to that point, I just want to highlight one of the real absurdities of the argument that this thing can continue basically indefinitely. In 1807, Governor Thomas McKean was impeached. His friends somehow got to the Senate and said, hey, hold off on the trial. Never tried. According to the respondent's argument, the Senate not only could, but has a duty today to try Thomas McKean for the misbehavior in office that occurred in 1807. Now, let's talk about the consequences for public officials if there's never an end to an impeachment, if trial doesn't have to happen at some point in the legislative session. Number one, public officials are constantly under threat of impeachment. That's Thomas McKean's problem, although he doesn't mind it too much now. But number two, the Senate itself has its priorities submarined while this is going on, because it's being forced to consider and deal with a matter that should have been dead a long time ago. One of the other consequences that I kind of want to talk about is respondents' argument that Article 2 governs legislation only. First of all, that's Article 3. It's right in the name, legislation. But Article 2 not only incorporates by implication the sine die or expiry principle, but it also says, what's the minimum age to be a legislator? When does your term begin or end? The absurdity of Article 2 does not apply to impeachments is a former member of the General Assembly, the quorum requirements as well. One former member of the House can just send articles of impeachment to one former senator, and he can try them, and the person is thereby removed from office if Article 2 doesn't apply. Because Article 2 establishes the precedent conditions for the body in question. So I think if you look at text, whether expressed or implied, you look at purpose, you look at structure, and you look at the consequences at issue here, we have a series of strong indicators that, just like everything else, whether it's building a bridge, rebuilding I-95, criminalizing something, or, by the way, the removal of someone from the legislature, impeachment is legislative business too. It's the business of the General Assembly.
So, counsel, I don't think if we go down the policy rabbit hole, there's a lot of bad policy on either side. What I think is interesting is, if I'm an elected official and I'm impeached by the House, one would think I would want a speedy Senate trial, right? That I would want to get that cloud lifted. I can, again, if we go down this rabbit hole, envision a situation where a Senate in the control of a majority, but not a supermajority, realizing they could not convict, might rather not have a trial and just let, if we adopt your theory, the legislative session end, which does not give the accused civil officer due process, the right to have the accusations decided. How does that cut on your argument, if at all? And again, Justice Weck may probably be right. None of this really matters. We have to look at the text of the Constitution, but if there's some ambiguity, we probably have to consider the different alternatives.
So I'm sorry, can you provide just the factual hypothetical?
Factual hypothetical being House impeaches, Senate majority is of the view that they don't have 2/3 to convict, meaning clear, so are content with letting the clock run out and allow the cloud of impeachment to stay, even though the civil officer is clamoring, I want my Senate trial. And the majority says, well, there's no way we're going to get a 2/3 majority. We're just going to let the clock run out, and we're happy with just letting that person be impeached without a trial.
May I pile on to that just one layer? If you looked at it that way, whether he goes to trial or not in the Senate, he's not unimpeached. The Senate conviction does not unimpeach you. You are impeached forever,
Right.
correct?
And you happen to still have been impeached if you are acquitted.
Right.
Yeah, but you're clear to the charges. Just like you are forever federally indicted, if you go to trial and you're found not guilty, people are going to remember the not guilty, you know?
So, to your point, I think what I would say is, if a civil officer wants to force the Senate to try him, I think, and again, we haven't addressed this, so this is kind of off the top of the head, but I think he has the same or similar remedies that District Attorney Krasner has here, is to go do something about it. Ask the court to say, which respondents argue, you have a duty to try this case, go.
Well, now under that principle, you're saying there's a mandatory duty to hold a trial before sine die.
No. I'm not saying there's any mandatory duty. Respondents are. It's possible that there's not. But if there is a mandatory duty, yes, it would be during the General Assembly.
Counsel, if I might, what I found, what I can't come up with a legitimate answer to is, if the impeachment articles don't die at the end of that continuing General Assembly, when do they die?
Never.
And textually, although not perfect, the only way to give a end date to that those impeachment articles is to interpret it the way that you are arguing.
That's correct. Otherwise, the Senate can still try Thomas McKean today, or for that matter, the 1685 impeachment of Chief Justice Nicholas Moore, because William Penn said, don't hold the trial.
Well, I don't think he'll show up.
I agree. But that merely illustrates the principle in its absurdity.
Well,
if
no,
there's no end date.
Isn't the principal end date, so the remedy is to deny the person to hold hold elected office again, right? So isn't the remedy that it dies when that person can no longer hold elected office?
Or that person dies?
Well, yeah. I mean, isn't that, I mean...
Bearing in mind the court's recent indications, let's not say absurd when we don't really mean it. I think it gets to be a little absurd to say, you know, if you're impeached at 25 as the, you know, a judge of the Commonwealth Court, you have to wait until you perish to know that the impeachment.
But however absurd it might be, I mean, the discipline there is the electorate, right? So, I mean, the Constitution says all impeachments shall be tried by the Senate. So the impeachment of McKean in 1807 was an impeachment, and if the respondents are correct, the Senate today could get up and say, we're going to try Governor McKean, and the discipline would be that the public would presumably impose a consequence by voting such buffoons out of office, right? And they're not getting anything out of it because McKean's dead anyway, right? So is it really that problematic?
Well,
Um,
in your thinking, to allow for the Senate to pick up whatever kind of moribund impeachment was voted by the House?
Well, maybe not, because first, if they're right, the Senate's response is, well, we had to. But, and here's an interesting extra feature of the carryover impeachment, let's say there are no other issues in the election, and before the election, the only issue is, should we impeach Larry Krasner? The people go to the polls, they vote, they say, heck no, we shouldn't impeach Larry Krasner. If you let it carry over, then there's no one to hold accountable, because the House, it's changed. And so the Senate, according to them, has to do this based on what the 206th House said they had to do. Again, this creates just a mismatch in terms of political accountability and democracy. So I think the real bones of contention in this case are the respondents' sort of quasi-originalist argument about how did the practice of impeachment proceedings become incorporated into Pennsylvania. And as you might have gathered from my reference to the frame of governments, I've spent a little bit of time in the area, and I'm happy to provide some background. But as Mr. Summers indicated, it's been extremely infrequent. It's been highly politically charged. Most of it happened before judicial review was in its adulthood. And we don't know from respondents or from the records why anything happened. So let me just take us on a brief tour. Thank you.
Just begin with Penn's childhood.
So in the colonial era, there are 3 attempted impeachments. William Penn and or the Privy Council say you don't have the authority to do that. Under the 1776 Constitution, there's one impeachment of a judge, he's acquitted. Under the 1790 Constitution, which is the operative constitution during all the carryover impeachments that they're talking about, one person is removed from office, and that's District Judge Alexander Addison. Everybody else is either never tried in the case of Thomas McKean, or they're acquitted. We don't know what was raised. We don't know why they were acquitted. It may well be that someone said the last term lapsed. Oh, well, that's an acquittal. We don't know. Since 1825, it's been basically nothing until the 90s. So I just want to briefly caution the court from simply importing what Parliament does to the early republic that said, we're not Parliament. We don't have a supreme legislative body. We have 3 branches of government with defined powers. And we don't have the divine authority of kings, albeit tempered by popularity. We have people at elections every X years saying who is going to have the authority to act on our behalf. If the impeachment in this case is permitted to stand, what we will be saying is the old legislature, its conduct is still valid. And if the election is to have significance, it's that power, that mandate that they had, ends on December 1st. Thank you so much for your time.
Thank you.
Thank you, Mr. Woods. All right, Mr. Haverstick, you've been waiting a long time for your time to shine.
Well, I'm listening to some good lawyering, Your Honor.
Good afternoon.
Madam Chief Justice, Your Honors, may it please the Court, my name is Matt Haverstick, and I represent President pro tempore Kim Ward. With me is Mr. I am blanking
Rob
out.
Gracie.
Yes, thank you. Mr. Robert Gracie, who's representing Representatives Bonner and Williams. I am going to be arguing both the adjournment by sine die issue and the civil officer issue. Mr. Gracie will be taking the balance of the argument. And I dare say, Your Honors, I think, with your acquiescence, I can probably get through my arguments in a couple of minutes, because I do think that the two arguments I'm going to talk about today are relatively straightforward.
We're certainly not going to rush you, Mr. Haverstick. We've been very generous with the time allotted to your opposing colleagues.
And I appreciate it, Your Honor, but it's your show. And in any event, I don't think there's that much to say about either of these, because I think they are straightforward issues. And let's start with sine die. I think there's an acknowledgement that there is a long historical background and predicate in the Commonwealth for impeachment having nothing to do with adjournment sine die. And we can discuss the merits of the British parliamentary system, but I think we have to acknowledge that for several hundred years, Britain's parliament, in which individual legislators are elected, just like they are here, acknowledged that impeachment and prorogation or sine die don't have anything to do with each other. 5 times in our Constitution's somewhat modern era, impeachments have survived between sessions and gone past sine die. The Attorney General's office issued, I think, a well-reasoned opinion, and we cite it, explaining why sine die principles don't apply to impeachment. I actually stopped up to get the annual copy of Vince's Blue Book from LRB, and for what it's worth, Vince agrees with me too. Sine die is not affected, or impeachment rather isn't affected by sine die. But look, there are good reasons for that, and I think the key to understanding is to look at in re Grist, because I think if you overlay Article 6 on Grist, you understand that functionally, when you try to compare Articles 2 and 3 and what is commanded of the legislature qua legislature in those 2 articles, it is substantively and functionally different than some of the other, not many, but some of the other roles assigned to the legislature having nothing to do with legislation. And as Grist points out, one of those is constitutional amendment. And I think that case, it's old, but it's still on the money. It talks about the fact that, hey, look, Articles 2 and 3 don't talk about amending the Constitution. And I forget what number it was in that Constitution, maybe Article 14, I don't remember. But that article that deals with amending the Constitution doesn't mention Articles 2 and 3. They're designed to be discrete functions and discrete sets of controls on a process and that is not supposed to be legislative. And here you can say the same thing about Article 6. Yes, we use the House of Representatives, one half of the General Assembly, as the prosecutor. And yes, we use the Senate of Pennsylvania, the other half, as effectively the jury. But they're not legislating. So all of the considerations we think of that justify from a public policy standpoint sine die and why that might be a good thing for legislation, we can pick up and put over here, because they're doing a very, very distinct role, they, the 2 houses. And I think there was some recognition that those roles are discrete and not temporally related in the way legislation is.
Could I ask you, Mr. Haverstick, is it in Article 2 that the age qualifications appear?
I think so, yeah.
Okay, so would that mean that since impeachment is a freestanding silo having nothing to do with Article 2, that we could have an 18-year-old House member and a 22-year-old Senate member doing the impeachment because they're not bound by Article 2 in any way?
No, and no more than it means that in that scenario, that same underage legislator could amend the Constitution. What Articles 2 and 3 do is explain how you constitute the body and then set some of the duties for that body when it's legislating. I think practically speaking, when you're thinking about Article 6, somebody had to do it. And so there was an assignment to the legislature as constituted to do it, but not explaining how it was done, and certainly not grafting on its Article 6 responsibilities, which are responsibilities. They're not rights. They're not privileges. It's a duty engrafted on them, which is a very different function than legislation.
Would your argument be stronger if we were exploring Article 3, which is entitled legislation? Here, Article 2 is in view, which provides that the General Assembly shall be a continuing body during the term for which the representatives were elected. Why is that off the table when we consider the impeachment provisions of Article 6?
Well, I think two primary answers for that, and let me give, I think, the overarching answer, which is, if that was the intent, with the breadth of history that we now know of in America, in Pennsylvania, in Great Britain, from the Attorney General's office, when both, well, I know 6 was, and I think 2 was amended in 1968. I forget about 3. In any event, with all of the history of impeachments, and you're rewriting Article 6, and you're rewriting at least some of Articles 2 or 3, if there was an intention to change the understanding of the General Assembly about its roles, again, qua Article 6, that would have been the time to do it. You would have rewritten Article 6 for public office to say, in Section 6, when you're doing an impeachment, you have to follow whatever the rules are in Articles 2 and 3 in terms of sine die or prorogation or expiry of the impeachment process. And that's not in there. I think the other answer maybe flows from my first, Your Honor, and the reason I believe that that's not in the Constitution as amended in the 60s is that the framers understood, yeah, impeachment's different than legislation. We have a legislative process that's in Article 3, and we have the composition of legislature in Article 2, but we want impeachment, just like we want amending the Constitution, to be different. We're putting them in a geographically distinct part of the Constitution. They're not with the other parts. They don't mention each other. They're not interrelated to each other. They don't require each other to be implicated or to be activated. So I think there's an understanding in our Constitution that, yes, we have this discrete section controlling removal or impeachment. We're going to have the legislature do it in different parts, in different orders, in different roles, but they're not going to be legislating. That's why it doesn't have to go to the governor.
What I struggle with is Article 6, Section 4, Section 5 refers to the House of Representatives, and 5 refers to the Senate. Nothing in the Constitution otherwise would suggest that you could disassociate those two terms from the concept of the General Assembly. And your argument is based upon the premise that somehow you can do that the House of Representatives is something other than one half of the General Assembly.
Well, I think for purposes of impeachment, in some respects, it is. I mean, there's two ways to really identify the House and the Senate for purposes of impeachment. One is just, how do I find those things? Like, how do I know what I'm talking about and who I need to talk to when I'm talking about the House in its role as prosecutor? But the other is understanding once I identify, who those group of people are who are going to be the prosecutors. In Article 6, then I'm talking about what they do. And I agree with you. I mean, you have to, in some level, reference back to Article 2 to understand, okay, what's House of Representatives? What do they mean by those words? Well, I guess they mean the thing that we're talking about in Article 2. But that's just who they are, not what they're supposed to do in Article 6. And in Article 6, what they're supposed to do is be prosecutors, and what the Senate is supposed to do is be a jury. And in that way,
any concept of the General Assembly? Because that's what we're doing.
Yes.
That's what we're doing.
Yes.
I mean, if we follow your line of argument, the concept of General Assembly becomes meaningless.
I'm not sure about meaningless, but I do agree. You have to conceptually now, in the way the General Assembly maybe denotes, certainly connotes, interactivity between the two branches, and they're codependent on each other to get their primary job done, which is to legislate. In Article 6, they're not symbiotic in this. I mean, they're not codependent anymore. One has one job, the other has the other job. I mean, they have to interact with each other, I mean, because the prosecutors have to present in front of the jury. But it's not.
That, to me, suggests that there are 4 branches of government. You have the House of Representatives, and you have the Senate, and then you have the other 2 of us. And that's the disconnect with this. And in addition to the temporality issue that I expressed earlier, if it doesn't end,
Well,
it's in and die, when does it end?
and I do want to talk about that, but I don't think conceiving of it as that many different entities is any different than the way we look at the General Assembly when it amends the Constitution.
But that's a different article that has its own set of procedures that are contained within it, which is not like Article 6. Article 6 is sui generis, and there's no question about it, which is what makes it so difficult, obviously.
Which is why, one way or the other, I think it'll be good for the Commonwealth to have an impeachment decision. You know, people will be probably talking about this 100 years from now, like we are with Grice. Look, there's more instruction. The Constitution is more of an instruction manual for the House and the Senate in the amendment process, but and I think this is a critical conjunction. I mean, you said yourself earlier, Your Honor, there is a distinct political component to impeachment. So I think that the Constitution sets out broad parameters for what the House is supposed to do and what the Senate is supposed to do, and bounded by due process considerations, I think they have a lot of leeway to figure out how they're going to conduct the trial.
That's what's interesting to me, because I do believe that there's a political component to this, obviously. However, recognizing that, to me, adds credence to the notion that once an election takes place, the political will has been spoken, and that concept of the political component of this, to me, fits much more comfortably with the termination of the articles impeachment, with the termination of that particular General Assembly.
And I don't think so, because I think the duties are discrete and broken apart and largely, I mean, in the same way that if you have a trial that's proceeding before an election and after an election in a petite jury, that somehow the change in elected leaders and who voted for those elected leaders on the jury mandates that jury that something should happen after the election to the petite jury to change its composition to reflect what happened in the election. If you conceive of the Senate as a jury, which I believe you must, that's really an irrelevant consideration.
Well, but it's a jury expressing political views. Your arguments are strongly tied to the notion that this is purely and simply a political process.
No.
I get that.
Well, no, I don't think it's purely and simply. Not at all. Not at all. I don't think it's purely and simply. I think there's an undoubted political component to it. But let's go with your hypo, Your Honor. Let's say that's right. Let's say that there in the Senate and in the House, there is a significantly different political feeling after the election. Will that not be manifested in the verdict that comes out of the Senate? The impeachment's done. It's like an indictment, right? I mean, that's done. It's, you know, look, the reflection, I guess, of changed political presentment could be, or sentiment could be, the House never goes across the hall and tries the case, and you know, you sit there as the jurors and say, well, they didn't put a case on, so they win, or they lose. But if there, if we do want to be, from a policy standpoint, sensitive to an election having an impact on the jury, well, then the jury will, I suppose, accurately reflect the political mores of the day by whatever it does when it hears the evidence.
If you can accept the proposition that the Senate should be acting upon a now defunct House of Representatives will.
Well, and I think that is probably something that goes into the calculus for the jury. But I also think that the act is done once the House's role in terms of generating the document is done. That's done. It's finished. It now goes over to the Senate for its job.
Do you agree, Mr. Haverstick, that view relies upon the premise that the sine die rule does not have any application in impeachment? In other words, you concede the sine die principle today?
For legislation? Oh, absolutely.
Okay.
Yeah.
Just fair.
Yeah.
Work with me here. So
Thank God we're not arguing over this.
Yeah,
so
Brown
you're
versus
conceding-
Brancata wrongly decided.
You're conceding that in the legislative arena, the sine die principle applies, but you maintain that aspect of Article 2 has no application in impeachment, right?
Correct.
Okay. So I'm still interested in understanding the basis upon which you pick and choose which aspects of Article 2 retain viability in the Article 6 context, because, for example, I've already asked about the age requirements, which you think are distinctive or distinguishable. What about quorum? Why would we insist that Article 2's quorum requirements would apply, for example, in impeachment?
Well, again, I think there are
Couldn't
some.
the Senate, in other words, couldn't the Senate, by hypothesis, make up all kinds of rules for the trial of an impeachment that would violate Article 2 under your argument?
I think, to take my argument to its logical extension, it could. Now, but it could do that anyway, because if you assume that impeachment is not a legislative process, then it's guided solely by Senate rules. And at that point, that's not justiciable. Now, you said today, and I think the right answer to that kind of wacky behavior is, well, they get voted out of office. If they decided to they in the Senate decided to disregard Article 2 rules on quorum, let's just say quorum, they had 3 people, and they got a conviction because all 3 voted on the impeachment articles. First of all, you'd have a problem in both caucuses. I think there'd be plenty of people in both caucuses who would never stand for that, but they're going to get voted out of office if they do that. But yes, I will grant you that the Senate has the ability to control its own rules in this process because, again, it is distinct from legislation, bounded again by due process. There's got to be at some point, and we could sit here and think of a point where it's so crazy that that's obviously violative of certainly procedural and probably substantive due process. And to cap this off, if there aren't any more questions, the functional problem with trying to crowbar an impeachment process into 2 years, I think, is manifest. It means you have to get the trial done within 2 years. So what happens if House? First of all, there's an impeachable offense almost immediately. It doesn't happen, like it might in real life, where it happens halfway through the legislative session. But it happens the first day of the legislative session. The articles come over. Senate has other important business, or COVID happens, or something happens, and you can't get the trial done, but you're in the middle of it. Well, then what happens? You start the trial again? I don't know. And I think that's I think that's why the process and the practice has developed over the centuries.
Why is it not an answer to that, Mr. Haverstick, that if the time period lapses and the conduct is sufficiently egregious to support articles of impeachment, that irrespective of some changes in membership, that the new body would reinstitute the article.
That might be how, well, that's how it should. I mean, absent reliance on sine die extinguishing anything, that's exactly what should happen. The trial should just continue on, just in the same way that when a couple of jurors get sick and have to go off the panel, you put in the substitute jurors, and they've been listening to the evidence, and and they decide based on their consciences and the facts and the law what an ultimate verdict will be. So yeah, I think that's a perfectly acceptable.
I meant the new body starting again to vote on articles. In other words, why is it constitutionally implausible to say that this House of Representatives tried to get the impeachment done, they didn't finish, or this scenario happened, and then as of December 1, the newly sworn House, it's incumbent on them to vote articles of impeachment. Why is that constitutionally implausible?
Well, because I think you may have answered your own question, Your Honor. If they voted out the articles of impeachment in the House, they've done their part. That part's finished.
But if it dies on the vine, they could do it again in very short order if they agree, if the new House members agree with what's been done. They can reinstate it.
Well, and that has, I mean, I think situations like that have happened. I mean, there is one of, I think there's one example of a judicial impeachment where the articles were revoked and then reissued in the next legislative session. Now, look, I'm query why they would have to be revoked if they just died a natural death as soon as the session ended. But sure, they could do that. Of course they could.
Mr. Havasick, that does. I had two questions, and one is along that line. So, Mr. Krasner's counsel seems to have a very narrow view of the power of the Senate when it comes to consideration of the articles of impeachment, that they must just have a full-blown evidentiary trial and can only render a decision. Is there any do you believe there's any constitutional constraints on how the Senate resolves articles of impeachment?
Only at, again, the outer bounds of conduct that would offend due process. I think there is a large universe of ways that the Senate could deal with it using its own resolutions and own rules to manage an impeachment process that that don't necessarily have to be a full-blown trial in the way that I think that the district attorney
and one could very well be, I mean, again, we're hypothesizing, but Mr. Krasner submits a motion to dismiss to the Senate and says these are not impeachable offenses, or this, you can't proceed with the trial because of sine die, any number of these things.
Yes.
My second question then was, I don't think it can be that sine die has no application, in the sense that if the House introduces articles of impeachment and then the session ends before they're passed, that would be sine die.
Yes. And I agree. And my argument is premised on, again, there being two sets of distinctive duties and assuming that the one has been accomplished as it has been in this case. But I agree with you. If they were in the process of getting impeachment articles together and they didn't finish before sine die, well, then they haven't done anything and they have to start all over again.
And along those lines,
or continue going.
Yeah, along those lines, supposing that they do get it done, like they did here, and then you have the new body sworn on December 1, and the impeachment managers want to take a knee because they're no longer, the majority flipped.
Right.
So do you maintain then that the minority can legitimately prosecute in the Senate? And if so, how do you address that cold dead hand argument from a Democratic theory perspective?
I should have thought of this one last night. My instinct is that because we acknowledge impeachment is heavily politically overtoned, that it would not be permissible for the minority to authorize itself to go over and try to prosecute a case in the Senate if the majority, both the Speaker and the Majority Leader, did not want that to happen. That seems...
But doesn't that conflict with your argument? If the impeachment vote in the House in the prior session is a closed circle, it's a packaged thing. There it is. And ostensibly then, if the new body, the December 1 body, is irrelevant to that analysis, then that body oughtn't to be able to control the prosecution of that valid thing you're talking about.
No, because it's a distinct duty from... The House really has two prosecutorial duties. One is to generate the charging document. The other is to prosecute. So it can generate the prosecuting document. I mean, we see this in real life all the time, where a charging document is generated, and then there's the decision to not move forward with the charges, and they're dismissed or they're withdrawn, or something else happens.
That
so
whole concept, oh, I'm sorry,
No.
go ahead. That whole concept, though, seems to work against the proposition that this is all one, or this is two separate things that can be finished and then tried and finished in the Senate, because the House does have that continuing obligation to send House managers over and prosecute. It mucks it up a little bit.
A little bit, but I think they're still very discrete duties. I mean, they are very, you can define very sharply and clearly when the duty to generate the charging document is done. I mean, you know it. It's not subject to debate about when it happened. It happened. And then there's the corresponding duty, if there's a political will, to take that document and try the case in the Senate.
I think it would be an interesting case, probably more of a headache than this one, if we had a situation where the new majority of the House post-election chose, as Justice Weck said, to take a knee. And somehow, some way, the minority, which has no power really whatsoever, files a mandamus action in Commonwealth Court to say the majority must now, this new body must now proceed with the trial. That would be interesting.
But that's the end result of your argument.
No,
He said they couldn't do that.
Yeah, but that's inconsistent with the predicate of his argument. I mean, if the impeachment articles are a done deal, then they have to be tried.
No. I mean, I think to the contrary, Your Honor. I just acknowledge that in those two distinct duties, there's the charging there's the obligation to create a charging document, and then there's the obligation to prosecute. And I said, I don't mean in the real world, but in the non-impeachment world, there are lots of times where the prosecutors accomplish task number one. They create a charging document, and then they make a separate decision to not move forward with that charging document. So
and they could be impeached for that.
I guess.
Well, if it's the majority, it's going to be hard to pass articles of impeachment.
But no, I don't think you set yourself irrevocably on a path to try the case simply because you've charged the case.
Counsel, I've saved this question for you. Article 6, Section 5 says that when sitting for the purpose of the impeachment trial, the senators shall be upon oath or affirmation. What is the oath or affirmation that they take?
I think it's probably going to be the same oath that's articulated I think earlier in Article 6. I mean, there's a discussion of what oath you have to take.
You have to take the oath again.
Well, just like a juror does, sure. I mean, I think that's a formality that jurors do to signify that they're doing a task that's different than their legislative task.
And what is that oath? To uphold the Constitution?
I think so, yeah. I think it's, I mean, again, isn't it Section 1 of Article 6?
I don't know if it's referring to the same oath or affirmation. I mean, it seems odd to me. I would have thought that there may have been a different oath or affirmation that had to be taken since an oath or affirmation had already been taken, but maybe not.
And that would be one of those ones that would very likely be covered in whatever the resolution is that sets the ground rules for the impeachment trial.
Mr. Haverstick, what else do you have for us?
I will briefly address, or as long as the court wants me to, the civil officer issue. again, referencing Article 6, that title is public officers. This court, I think, repeatedly has held that a district attorney is a constitutional officer, an officer subject to Article 6, a Commonwealth officer. There's no language in Article 6 that limits application of the Constitution to only a statewide officer and therefore only a statewide elected officer. I mean, there's I think you, the other appellate judges, the treasurer, the auditor general, the attorney general's office, or the attorney general and the gov, and I think that's about it.
Those are statewide officials.
Yes.
Aren't they different animals than these county row officers?
Well, they are, but I think the interpretation that's being proffered by the district attorney is those are the only people who are subject to impeachment. Everybody else, if you're anything less than a statewide officer, whatever that means, you're not subject to the clutches of Article 6. Look, certainly I'm not going to suggest that the district attorney of Philadelphia is a statewide officer, but I will, and I think we all have to acknowledge that he is the Commonwealth's representative in the city and county of Philadelphia. When he files cases, it's on behalf of the Commonwealth. It's not on behalf of the city of Philadelphia. In fact, the city solicitor's office and the DA's office have thought about that before in front of this court about, who speaks for the Commonwealth in court, and the winner was the district attorney. He's the Commonwealth's representative there. His power derives from the Commonwealth.
Supposing he was impeached, would that mean that he could run for citywide office in Philadelphia? Or
well, then we'd have to get into it. We'd have to get into a discussion of the rest of Article 6, where it talks about what offices you're disqualified from. And I think there are going to be a lot of them, arguably, that, yes, he would be disqualified from running based on precedent from this court, which is held that some of the city offices, like the Prothonotary or some of the tax folks, are civil officers or public officers.
School board?
Well, this court... school administrators, certainly. I mean, this court is so held. School board, I have to think about that one.
I mean, anything under this Commonwealth, does that mean that any office, anything in the Commonwealth is under the Commonwealth, right?
No, it doesn't. There are offices which are denominated or have been held to be municipal in the sense that they are purely creatures of that municipality, and they aren't Commonwealth. They aren't cloaked with the authority of the Commonwealth. They're not.
Dog catcher.
Pardon me?
Dog
That might be one. Yeah, that might be one where they're not getting significant amounts of Commonwealth money. By the way, the DA's office gets 65%. They all do 65% of their funding from Pennsylvania. So,
but isn't this district attorney by statute designated as a county officer?
In the Constitution, he was designated as the county officer. But,
and that doesn't help us with this?
No, because, well, I suppose it ultimately doesn't matter, because in the trio of Arlen Specter cases, they wrestle with the idea of, okay, now that Philly is home rule and county officers or city officers, what does that mean for application of like the civil service exams and things like that? And the holdings from those cases kind of are all over the map. But the one thing they're consistent on is, well, the DA is subject to Article 6. He is the representative of the Commonwealth, and he's subject to Article 6, whatever that may mean for whether he's covered by the civil service exam in Philly. And they're not, by the way. They're not. I think that's in the charter, but they're not.
Is it relevant to the constitutional analysis that members of the General Assembly, under your construction of this, from all over this Commonwealth, could in concert act to oust somebody who represents, who was elected by the voters of a place that none of them were elected to represent, except a few of them?
I think the answer is naturally yes, and the break on that is in part the political process and in part the one you've oft identified today, which is, you know, vote the bums out. But I think evaluating the propriety of impeachment based on it being contrary to the will of the voters denies what it is. I mean, the impeachment by design is supposed to be something that runs contrary to what the voters wanted. That's why it doesn't happen very often, and it's why there's so many safeguards in the I mean, it's not like Senate address.
Except that if I could just jump in, I think that's a very good point, that it is anti-democratic in that sense. But it's apples to apples when the impeachment is by the statewide legislature of a statewide official, because they're all you know, selected by the statewide electorate, right? But here, by hypothesis, you could have you know, 66 the legislators from 66 counties acting in concert or by majority to, or 2/3 in the Senate, to impeach a person elected in one county. And does that run against our canon of construction, which supports enfranchisement of the citizens?
No, it doesn't, because the people that we're talking about, civil officers and public officers, are charged with duties and responsibilities, financial wherewithal from the Commonwealth. I mean, the fact is, every district attorney in the Commonwealth gets paid the same and gets 65% of the office's funding indirectly from the General Assembly. It flows through the AG's office in a restricted line, I think. So, in effect, everybody in the Commonwealth is paying for some of these officials, or at least this particular one that we're talking about today. So, no, I would not consider that anti-democratic. I certainly hope it doesn't. I hope impeachment isn't a regular process, but I don't think. Again, if determining that an impeachment is improper is based solely on it being anti-democratic, then then we might as well just rip that article of the Constitution up, because it sort of is.
Would you like to wrap up, Mr.
I
Dobbs?
would.
Can I just ask one other question?
Sure.
Do Section 6 and Section 7 of Article 6 speak to two different types of civil officers?
I don't believe that they do, no. I think that I think many of us wish that there was absolute consistency throughout that article about the way things are written. Now, you may hear from Judge Gracie or from Mr. Gracie that some of the distinctions, like the word "any," are very much by design. But in this case, Your Honor, no. I think public and civil officers all mean the same thing in both sections.
And I guess the part of that I have a hard time reconciling is that District Attorney Krasner, if convicted, couldn't hold any office or of trust or profit under the Commonwealth. So he couldn't be a statewide official, which he's not.
I think your interpretation is correct. If he was convicted under Article 6, under the impeachment section, then yeah, he would be ineligible for whatever class of officer we consider to be those given the public trust.
How about, could he run for district attorney again?
I don't think so. Your Honors, thank you for your attention today on these issues. They took way more than 5 minutes, but that's because of your very good questions. Thank you.
Thank you.
Thank you. Mr. Gracie?
Good afternoon. Chief Justice Todd, and may it please the court. My name is Robert Gracie, and with Saxon and Stump, I have the privilege of arguing on behalf of Representatives Tim Bonner and Craig Williams, who are the managers appointed to conduct the trial in the Senate if there should be a trial. As Mr. Haverstick indicated, I'll be arguing the remaining issues, and they are the issues of political question, non-justiciable political questions on two issues, and that two of the issues are not ripe. Before I get into my argument, Your Honors, I had approached the crier and the prothonotary. I came to realize as I was reviewing my brief, getting ready for the argument, that a citation had been inadvertently removed from our brief before it was filed. It's the blue part. It's a web link to the articles of impeachment in the Larson case. I was concerned, and I wanted to bring that to the court's attention because the citation otherwise makes no sense. And I have, the court all has copies of them. I also wanted to point out, I'm not exactly sure where to start anymore. It's a hard thing going last. Justice Donahue, you asked about the oath that senators have to take. It is in the record at page R143A. Which, I'm sorry? What is it? What is the oath is, I solemnly swear or affirm, as the case may be, that in all things pertaining to the trial of the impeachment of blank, now pending, I will do impartial justice according to the Constitution and laws, so help me God. It appears, so help me God is in parenthesis, so I guess that's up to the individual. Optional, thank you, I couldn't think of the word, Your Honor. And that's part of Senate Resolution 386, which is the procedural rules that the Senate adopted for the conduct of the trials of impeachment. Let me, if I might, there are some things that I will jump into, and I'm sorry that I'll do some jumping around, but because of the way the arguments have been presented and in line with the court's questions and the things that I think you might be interested in.
That's fine. We're nimble. We follow you.
I'm not sure that I am as nimble as I used to be, Your Honor, and I hope I do this well. One thing that I think I have to say, and I think it's worthwhile to start with, the articles are not drafted in the context of the common law crime of misbehavior in office. That doesn't mean they don't charge misbehavior in office, as the Constitution requires, but that's not how they were drafted. The House of Representatives didn't look at the definition in Bragg, and I submit to the court they didn't look to the definition in Bragg because Bragg was not an impeachment case. It was a removal case dealing with Article 5, Section 18, which I think was then L, now D4. And they also said, oh, by the way, and I submit it was dicta, that it's the same words, essentially, that are used in Article 6, Section 7 with respect to removal based on a conviction of misbehavior in office. But what did the General Assembly, I'm sorry, I don't want to use that phrase because I think it's important to separate. What did the House do? The House didn't ignore the courts. The House didn't ignore the rules. And I might note that my two clients are members of the bar, so when the managers were selected, and the third member who is not participating is also a member of the bar, I believe actually he's announced that he's running for Attorney General. So he's a high-ranking member of the bar. They're not ignoring the courts. They're not ignoring the law. What they looked to was the Larson case. And they looked to the Larson case because that was the last impeachment, unfortunately. I didn't mean it that way. I meant to say it was unfortunate that he was impeached Fortunately, that was the last impeachment we had 30 years ago or thereabouts. And I'm probably one of the only people in the room today. I actually had a part in the Larson case. That just says I'm old, nothing more. But that's what they looked at. And they talked about what Larson didn't say. And they said, we don't exactly know, the Larson court said, we don't exactly know what misbehavior in office is. But that's what the legislature looked to, and then it cataloged all of the activity in 7 articles that they accused District Attorney Krasner of being involved in. Does it say that he violated a ministerial duty imposed on him by law, or that he exercises discretion in a way based on improper or corrupt motive? No, because they weren't focusing on that, nor did they have to, because no court had ever said that that was the standard under Article 6, Section 6. So I can't give you a recitation, and our brief doesn't try to do it, that, well, here's how it proves that it satisfied Bragg. Maybe it does, maybe it doesn't. But we didn't, the House didn't try to do that.
But the Constitution does say any misbehavior in office, so that was there.
It does say any misbehavior in office. The one court that was asked to say, and quite frankly, the Larson court, the Commonwealth Court in Larson, said, you ask us to apply the common law definition. There is no judicial precedent to do that.
But you don't maintain that, fair enough, you don't maintain that it's outside our authority to interpret that today and apply that as against these articles, do you? And the guy behind you on the wall is looking at you right now.
You know, as many times as I've been,
Marshall.
Thank you. This whole exercise today, Your Honor, is an act of judicial review. You're doing what courts do, and we want you to do what courts do. But sometimes, in exercising judicial review, and all of the Baker versus Carr line of cases, and this court's cases, William Penn, Robinson Township, Sweeney, to get to the point to make the determination as to whether or not we should abstain and not exercise and say what the law is an act of judicial review. Now, the specific answer to your question, Your Honor, should you, this court, rather than the Senate, say that misbehavior in office means what we said it means in Bragg, even though it was a little different context, we say those words, and I'll get to the argument in a little bit that they're not the same words, but that those words, those 3 words, misbehavior in office, mean the same thing in Article 6, Section 6 as they mean in Article 6, Section 7. Can you say that? Do you have the power to do that? Absolutely. I submit to you, you don't have the authority to do it. You shouldn't do it because it's a political question committed exclusively to the General Assembly.
So your argument is that interpreting the language of the Constitution falls to the legislature?
In this context, Your Honor, it's very rare that that situation will present itself. But in this context, and I'm going to screw up the quote, the textually demonstrable allocation, whatever Baker, which this court has said repeatedly, the first of the Baker factors. I submit to Your Honors, that this is one of those rare cases.
Then in an impeachment trial, Mr. Gracie, if you're correct that misbehavior in office is whatever the General Assembly says it is, then why wouldn't the General Assembly be within its rights to say, in the limited context of impeachment, due process is whatever we say whatever process we say is due.
I suppose they could, Your Honor, but I think again of this court's, I believe it was Sweeney decision, where they were ruling after Mr. Sweeney, I think it was Sweeney who was expelled. I never get the parties right. After that happened, they said, because he complained that he was denied a fundamental right, they said, no, you weren't, because before you could be expelled by the House had to muster a 2/3 vote. That gave you all the process that you were due. I imagine, Your Honor, hypothetically, that a Senate could trammel an impeached, accused person's rights in a way that would be foreign to jurisprudence in this country.
But I just don't understand the principal basis upon which you could say misbehavior in office is whatever they say it is, without also saying that the process that is due is whatever process they say is due. It seems to me it's the same thing. It's a box, it's a black box, and they control it.
In large measure, they do control it. In large measure, they do control it. Somebody earlier referenced the possibility of some sort of a king's bench, I guess, after the fact. I forget what the exact context was. I think it was in response to a question that Justice Donoghue posed as to what post-impeachment process there might be. And while
I don't see why it is that, I'm sorry to interrupt, just one more follow-up on this. I just don't see why you would say that other aspects of the proceeding would ostensibly be subject to judicial review, whether ex ante or ex post, but misbehavior in office is something that is absolutely immune from judicial review. It's in the Constitution.
Well, all of Article 6 and every one of its words, starting with the House shall have the sole power of impeachment, it's all in the Constitution. And you do get the opportunity to interpret, to make sure, although we say it's dicta, and I think by any definition it is, the language from the 1938 Dauphin County grand jury case, as long as it's within constitutional lines. There's some suggestion in some of the cases from the other states that we cite that constitutional lines includes due process. And there's no suggestion here, hypothetically, I could understand going off the rails, going outside the lines. But there's no suggestion here that anything went outside the lines, other than he claims, the district attorney claims, I'm not a civil officer, which, by the way, we didn't challenge as being non-justiciable. If somebody tried to impeach a doctor, if the House tried to impeach a doctor, I would hope that the doctor could get some relief because he's not a civil officer. We never.
It's inconsistent, Mr. Gracie, to say that under your reading, the Senate can deem anything any elected official's conduct as misbehavior without any bounds whatsoever, even though the word misbehavior in office, it's in our Constitution, and yet we can review a due process claim even though the words due process are not in our Constitution. Seems a little bit backward. And I don't see the principled basis upon which you are arrogating to the Senate the sole right to construe words in our Constitution while allowing us any power to review anything.
Well, the reason it goes to the Senate, in our view, is again the political question doctrine, which of course is part of the separation of powers doctrine, as you've many times explained. It's not without guidance for the Senate. It has to be, and you said it just a moment ago, Your Honor. I'm not sure that you intended, you only said misbehavior. It has to be connected to in office. It's misbehavior in office. They can't just define any misbehavior. Now, what's misbehavior? This court regularly says when we interpret the Constitution different from interpreting a statute where we look to the intent of the legislature, we have to look to find out, try to understand what was in the mind of the voters when they approved it. Now, this language or some variant, it goes back and forth between misdemeanor in office, misbehavior in office. I don't know that our Constitution ever used misconduct in office, but the courts say they all kind of mean the same thing when they've had the opportunity to address them. What did the voters think when they changed in 1966, I think it was, from misdemeanor in office, which was clearly a crime? At least in my understanding, crimes are summary offenses, misdemeanors, and felonies in Pennsylvania. Misdemeanor is a crime. And even in the 1938 grand jury case, misdemeanor in office means you have to be convicted of a crime. Well, of course, it's a crime. No problem with that. But then they changed it. It changed from misdemeanor in office, clearly a crime, to misbehavior in office. And then it's not all that it says. Again, the three words misbehavior in office appear now in Article 6, Section 6, and Article 6, Section 7. But the word before those three words is different.
Mr. Gracie, I think you're kind of going to a different argument in terms of getting into the substance of what is what's misbehavior in office and what isn't. I kind of want to stick to, at least I know where time is getting it on us all, but the concept that we as a Supreme Court of Pennsylvania do not have the power to interpret that provision of the Constitution at all. I think that's hard, at least for me, to grasp, because there doesn't seem to be a provision in Article 5 or Article 6 that says, and oh, by the way, only the Senate determines what a misbehavior office is, and there's no judicial review. I'm more interested in the idea of not whether we can address the question, but when. When can we look to whether the body, as we said in Dauphin County Grand Jury, acted within constitutional lines? If, for example, the Senate does convict for one of the articles of impeachment and that jury concludes, based on some legal charge from somewhere, juries are charged with the law, that there was a misbehavior in office, is your position that we are precluded from reviewing that determination to determine, as we said under the grand jury case, that that conclusion is outside constitutional lines?
Well, going back to that 1938 case, Your Honor, you said you have no authority to stay the hand of the General Assembly. And that was, they were trying to preclude, I believe it was the District Attorney of Dauphin County, from testifying before a committee that was thinking about impeaching somebody. There were actually two cases going on at the same time. They were holding for the court on one and for the legislature on the other. Whether or not you get a post-impeachment ability to review.
Post-conviction.
What did I say? I'm sorry. Yes, Your Honor. Thank you for the clarification, for the correction. It would tend to wreak havoc unless you did it in a couple of days. Because what happens after the impeachment? If District Attorney Krasner, and I did it again, what happens after the conviction? If the District Attorney is convicted, he's removed immediately. His office is declared vacant. The next person, however it works, and I know there was a recent change in the law with respect to the first assistant becoming the DA, but I don't know if that applies in counties of the first class. But there's a process in place, and eventually there would have to be a new election. What would happen in the meantime? Would that new person be the DA? You would be interfering with his or her authority if you got involved and set it down, even if you did it for expedited briefing. How could you? Who would be running the office? Would Mr. Krasner continue to run the office? That would be a real insult to the Senate if this court stepped in at that point and said, oh, no, wait a minute.
So you don't mind us stepping in now?
Oh, I do mind you stepping in now. That's why I'm arguing that it's a political question that you shouldn't be involved in.
On this political question theory, why would we not be why wouldn't we be well advised to assume that the framers, when they adopted the misbehavior in office words, referred to the common law definition, and specifically the failure to perform a positive ministerial duty of the office or the performance of a discretionary duty with an improper or corrupt motive. Why would the framers not have had that in mind when they used this misbehavior in office?
Your Honor, I can't say that they wouldn't have, because again, the framer, if we're talking about the members of the General Assembly who would have proposed an amendment for action by the electorate. And I think, and I don't remember, I've been reading so many briefs as I'm sure you have, I don't remember who said it, it might even be in ours, that you can't really trace the history. We know that the Pennsylvania Bar Association, when misdemeanor in office was changed in 1966 to misbehavior in office, said they were trying to regularize it and make it the same as the next. Well, the Pennsylvania Bar Association isn't the General Assembly, first off. Maybe that's what prompted the General Assembly to act, but I don't know what light that sheds whatsoever on what the electorate thought or what any voter thought. I think about my saintly mother, who probably voted for the amendment in 1966, and she probably thought misbehavior in office meant that they didn't behave well in office.
Perhaps I could ask it this way. Why would we be well advised to disfavor that common law definition I just read to you as being the meaning of this term in the framers' view, rather than your preference, which is just whatever the Senate wakes up and decides today or tomorrow or the next day or changes their mind to 2 weeks from now?
Well, you would be well advised in the first instance, Your Honor, and please bear with me here. You would be well advised in the first instance because the other sections, Article 6, Section 7, and Article 5, Section 18D4, require a conviction. That implies a crime. Article 6, Section 6, on the other hand, says any misbehavior in office. If you want to take that definition as you've appropriately stated it, take out the words misbehavior in office. Just take it out of Article 6, Section 6, and insert your definition. And it becomes a person, the governor and all civil officers may be impeached for a failure to perform a ministerial duty imposed by law or performing a discretionary act, et cetera, et cetera, et cetera. I think I did that pretty well. There's only one type of misbehavior in office. It might be performed in different ways, but it's not any. You've taken any out of the Constitution. And your canons say that every word, when possible, has to be given effect. And again, that when possible applies to legislation. We're talking about our fundamental document. It's any misbehavior in office.
Why shouldn't that simply mean that the only way to proceed under the one that has the word conviction is if there was a conviction in court, but that in the other one, the General Assembly does not have to wait for a conviction? The General Assembly can proceed and act based on the exact same facts, even absent a conviction, and even possibility in the event of an acquittal, where the person is acquitted in a criminal proceeding. Why isn't that a proper reading?
I agree with Your Honor that it's a reading, but I believe it discounts the different words used in different sections of the Constitution. And again, going back to the canons of construction and interpretation, different words are generally found to mean different things. The only, and we, again, as I heard Mr. Summers' argument, he focused on misbehavior in office. But you have to look at the words that qualify, whether it be on conviction of or any. They say different things. And quite frankly, part of that question...
Again, let me just interrupt. Any could mean a misbehavior in office that did not have a conviction. It could even mean a misbehavior in office that was an acquittal, whereas the other one requires a conviction. Why is that atextual?
I'm sorry, I didn't hear.
Why is that interpretation atextual?
Atextual. I didn't hear the last word you said, Your Honor. As I indicated earlier, that is an interpretation.
But, counsel, doesn't the last sentence of Section 6 support that precise interpretation? Because the last sentence talks about the person accused, whether convicted or acquitted, shall nevertheless be liable to indictment, trial, judgment, and punishment according to law. So it's anticipating a situation where someone may not have even been charged with any type of conduct. Or it could be that the person was convicted of some crime. So, I mean, isn't that what any means? Whether any either charged or uncharged, acquitted or convicted, misbehavior in office?
Your Honor, the way I've read that last sentence and the way I understand it is the fact that there has been an impeachment by the House and a trial in the Senate that results either in an acquittal or conviction does not bar subsequent action. You've kind of flipped it around. Although I mean, we can look at the Larson case itself where after he was convicted of conspiracy to violate the Drug Act, one of the 7 articles of impeachment introduced against him was based on that conviction. So it can go either way, but I don't know that...
That's what the last sentence says. It can go either way. Counsel, under your interpretation of who gets the who decides what misbehavior in office means, is it the House or is it the Senate?
Thank you, Your Honor. That's a point that I wanted to make. In the first instance, it's the House. And whatever the House concludes, God bless you, constituted misbehavior in office will bind the Senate. That's the charging document. If the Senate disagrees with the House's conclusion that whatever it has alleged in the articles of impeachment constitutes misbehavior in office, and I think, Your Honor, Justice Robson said it, they could grant a motion to dismiss. That's
totally unmoored to anything. It's not just akin to indicting a ham sandwich. They could have totally different ham sandwiches in mind. I mean, it's whatever the House wakes up to today and what they have for breakfast, and then they bring impeachment. And then tomorrow the Senate wakes up and they think of the polar opposite as what any misbehavior means. Can that really be what our Constitution provides?
Yes, Your Honor. And this gets back to, and we have talked about it here this morning, and it's generally something that's distasteful, particularly in the context of a court. It's a political issue. History is replete with examples of political impeachments. It's part of the system. It's part of the system that was built into the Constitution. That's why the Constitution in this regard has been amended many times. There's been talk, I don't know about in Pennsylvania, but in others, of giving the courts a role. The commentators say it's not something fit for courts. I think it was White or maybe Justice Story. It's not something fit for the courts to be involved in because it's essentially a political process. But there are protections against it. Some of those have been described already. Primarily, the two-thirds vote in the Senate. That's why we haven't had a lot of convictions on impeachment, because they haven't mustered the vote. The one that most immediately comes to mind goes back to the mid-1990s, not in Pennsylvania, thank goodness, but when Arlen Specter voted not proven.
The Scottish verdict.
Yes, whatever that meant exactly, but they couldn't get the requisite two-thirds vote. That's the protection. That's among the protections. That they be on oath, a special oath, Your Honor. Quite frankly, I've been wondering, what really does that mean? Well, I think it means, you really have to pay attention to this. And you're not supposed to be driven by whatever political leanings you might have, but fairly try the case. That's a protection. It has to be considered a protection because it was written into the Constitution.
You see, that's why I asked the question as to what precisely is oath. You're taking an oath to uphold the law. You're saying they're not bound by any law. They're taking an oath to uphold the Constitution. But you're saying they aren't bound by the Constitution. So, I mean, that's why I asked the question, what's the oath, and why take an oath if it's not binding on the conduct? We know what the law is. We know what the Constitution is. But you're saying that actually they don't have to follow it.
I disagree with Your Honor's premise that they don't have to follow the law or the Constitution. Like any elected official, the Senate, sitting in the trial of an impeachment, is bound to follow the law and the Constitution.
You're saying they decide what it is.
But they decide it, yes. Because, I'm sorry.
They aren't bound by the law. They're bound by what they decide the law is in any particular impeachment proceeding. That can't be the case. I mean, why take an oath to uphold the law and the Constitution if you are not bound by developed concepts of what that entails?
If that's the law, then what this court said in the grand jury case in 1938, where essentially the courts play no role, the courts are going to play a role, and the courts are going to play a role beforehand.
Well, I think that's, you're going back to the grand jury case, and I think that's it. The grand jury case was about procedural intervention. It wasn't about substantive intervention. It was about the courts somehow, some way, stepping in to interrupt the House process of going through the articles of impeachment. That goes to the procedural question, which is the one that I struggle most with in this case. This question that you're getting is substantive meaning of a provision of the Pennsylvania Constitution. And we certainly have recent examples where this court has decided issues, despite arguments about political question, of how the General Assembly is to execute its authority under the Constitution, whether it's the Environmental Rights Amendment or the Free and Equal Elections Clause. So that's, I don't know how this is any different than those. I'm struggling with the timing, but I'm not struggling so hard with the idea that under this court's precedent, fairly recent precedent, this court gets the final say on what that language means.
But, Your Honor, in those cases that you just referred to, the environmental rights, and I listed some of them earlier, the school funding case, The legislature had already acted when you spoke.
That's a timing issue. That's a timing question.
Well, it's a huge timing issue because you say it's substantive. I say it's procedural. Why? And you know my background. I was a prosecutor for a long time. I presented cases in court for a long time. And I might charge a particular crime, and the defendant, through his attorney, would say, this crime doesn't apply to me. That's not what the legislature intended. What would a court do if a member of the legislature, or if the whole legislature passed a resolution and say, this is what we meant? In all likelihood, you'd ignore it. There's some things that you'll look at, legislative history and the like, how a bill progresses through the various chambers. But you're not going to listen to them to tell you, this is how it's supposed to be applied. This is what we intended. That's a call for the court. Why? Not because you're a court, but because it's a proceeding in court over which your rules of procedure dictate. This is a procedure in the Senate.
But we interpret, fair enough, but then by your interpretation or your paradigm, all of our cases about the single subject requirement and all those other aspects of our Constitution about how this General Assembly does its business were all ultra-virus, and we were outside of our lane. Basically, your argument is everything that the General Assembly does as far as its own business is outside of our lane, so how can our decisions about such things as single subject rule and all the anti-log rolling provisions of our Constitution have any force?
Well, Your Honor, I disagree with your premise because, again, those challenges came after the General Assembly had acted.
And this challenge came after Krasner was impeached in the House.
And they challenged what was going to go on in the Senate. They didn't try to undo, I don't think they can, as has been discussed.
He has a summons from the Senate. He got a summons from the Senate. This is not an academic or hypothetical exercise.
And he has standing to bring the challenge. We raised the standing issue in the court below. We've abandoned it here.
My question is, so if we can't weigh in on what the Constitution's any misbehavior in office means, how did we have any business weighing in on anything else the General Assembly did under its powers in this document?
If I can use, I'm trying to remember what the case was. Powell versus McCormick in the U.S. Supreme Court, where the court said it was not a political question, and the court said, we can determine what the requirements to be elected to the House are. That's clear in the Constitution. That, I submit, Your Honor, is what this court has done repeatedly in the Article 3. I'm not an expert on those areas, but I think they're Article 3, single subject, et cetera, et cetera, et cetera. You're just saying what the Constitution says. Here, on the other hand, with respect to misbehavior in office, and the same arguments, quite honestly, apply to sine die. As a matter of fact, I wrote a note here to myself when Mr. Woods was speaking. He said this is purely a procedural constitutional argument. I agree. And that purely procedural issue belongs in the first instance in the Senate.
Now you're back to timing.
Well, I'm back to timing, and I know Your Honor doesn't like the idea that I'm telling you should never be involved, either
But that's your argument.
ex ante or ex post.
But your argument was just in the first instance, which suggests there's a second instance, and that we may be the second instance.
No, you said never.
I'm sorry?
You said never.
I did say never, and we take that position.
I wrote that down.
We take that position in our brief as to whether or not these issues will ever be ripe for judicial determination, because, again, it's our position that these questions are committed to the General Assembly under the political question doctrine.
Mr. Gracie, I think we're about finished. We've heard almost 4 hours of argument on this case. If you could sum up, I would appreciate it.
Daniel Webster would just be getting warmed up at this point.
I'm not sure. He was a little younger than I was during that time of his life, Your Honor. We appreciate the court's indulgence. I'm thinking that my clients may be watching the live feed and that maybe there are things that I haven't fully expressed, but I do believe that they are fully expressed in our brief. So as the court has no further questions, I thank you for your time, and I ask that you grant the relief that we've requested in our brief.
And be assured, counsel, we do look very carefully at your briefs. Nothing is waived if it isn't argued orally. And my compliments to all four counsel on excellent arguments. Thank you so much.
Thank you.
Mr. Minner?
Argument is adjourned.